Well, good morning. This is John Neerman, and it is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, May 19th, 2021. The time is 9:30 a.m., and I'll begin with the roll call. Good morning, Commissioner Lindley.
Good morning.
And good morning, Commissioner Janeka.
Good morning.
Our commissioners are all present. How about our General Counsel? Ms. Smith, are you there? Ms. Smith, you may be on mute.
I think there was a mute issue there, but I am here.
Great. Good morning to you. And how about our Public Interest Counsel? Mr. McWhirter, are you there?
Good morning. I'm here.
Good morning. I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who is here only to listen that they can watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration is now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item that you'd like to comment on, and we will do our best to accommodate that request. For those making presentations, please wait to begin your presentation until I or our General Counsel have asked you to begin speaking, and please check to make sure your line is unmuted before you speak. And with that, I'd like to thank everyone for being present, and Ms. Smith, I'll ask you to please call the first item.
The first item on the agenda is Old Business 1, which is a proposal for decision. I understand there are two representatives who wanted to address the Commission on this item, but that they may not be available until a little bit later. Would you like to go on to the next item?
Let's check real quick just to see if maybe they were able to get here earlier than they anticipated. Are Representatives Tinderholt or Cook on the line? Okay, hearing none, let's come back to them later in the presentations.
Okay. Item 1, new business item 1 was a motion for rehearing, but that motion was withdrawn, so the Commission will not be considering this matter. Item number 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by the Port of Corpus Christi Authority of Nueces County for TPDES permit number WQ00052530000 to discharge treated effluent from a proposed marine desalinization plant. The order of presentation should begin with the applicant, followed by protestants, the ED, and then OPIC. By letter dated April 30th, 2021, the Chief Clerk's Office, at the request of the Office of General Counsel, notified the parties that they will each have the following oral argument time. Applicant will have 12 minutes. Protestants will have 12 minutes collectively. The ED will have 8 minutes, and OPIC will have 8 minutes. The applicant may save time for rebuttal as it bears the burden of proof on this application.
Thank you, Ms. Smith. And I'll ask the representatives for the applicant to go ahead and identify themselves for the record, and then the floor is yours.
Yes, good morning. My name is Ernest Woodring of the law firm of Baker Woodring, and I will be presenting argument on behalf of the Port Authority of Corpus Christi on item number 2 on today's agenda for the commissioners. Port Authority represents the interests of the over 400,000 residents of Nueces and San Patricio counties, the city of Corpus Christi, and other local governments in the surrounding region. Port Authority is required to develop port-related industries that advance the economies of Nueces and San Patricio counties, and its efforts have attracted billions of dollars in private capital to the region, built the tax base of all local taxing authorities, and created employment opportunities for thousands of South Texans over several generations. To further promote a healthy local environment while ensuring protection of the environment, Port Authority is seeking a TPDES permit for a proposed seawater desalinization facility. The proposed desalinization facility will bring potable water to the Nueces and San Patricio counties that have suffered repeated severe drought conditions posing imminent threats of disaster to the public's health, property, and the economy in the region. The Port Authority supports the Executive Director's motion to remand this matter so that it can provide additional evidence in support of the draft permit. The Texas Legislature has expressed the importance of desalinization for the future of the state. As the Texas Legislature has stated, with this state facing an ongoing drought, continuing population growth, and the need to remain economically competitive, every effort must be made to secure and develop plentiful and cost-effective water supplies to meet the ever-increasing demand for water. The pressing need for new sources of potable water and the evidence in the record regarding the draft permit make a compelling case to grant the Executive Director's motion to remand. The record shows that the discharge from the proposed desalinization facility will not significantly increase the salinity in the Corpus Christi ship channel. At most, any increase of salinity will be less than 1%. In addition, the volume of the discharge will only be at most 0.5% of the daily tidal exchange flow in the channel. The natural salinity in the Corpus Christi ship channel varies significantly throughout the year, from 39 parts per thousand at the highest to 18 parts per thousand at the lowest. Proposed discharge will have a smaller impact than the naturally occurring increase and decrease in salinity, which is far more variable and extreme than the proposed discharge into the Corpus Christi ship channel from the facility. The ALJs identified issues with the modeling from the facility's discharge as being inaccurate. One, the depth of the channel at the discharge, and two, the ambient velocity of the water where the outfall is located. The Executive Director has requested that the Commissioners order the ALJs to reopen the evidence so additional modeling can be performed with updated inputs to address the concerns expressed by the ALJs. Port Authority supports the Executive Director's request for the remand to respond to the issues in the modeling that were raised in the contested case process and to provide additional evidence that the depth of the channel and other issues demonstrate that the proposed permit is protective of the environment and marine life. Port Authority supports this request for remand as it has supported other additional measures in connection with the draft permit to respond to the TCEQ's inquiries and to answer legitimate concerns about the proposed facility. The Texas Department of Parks and Wildlife raised concerns about the possible impacts of the discharge and requested whole effluent toxicity testing, also known as wet testing. Port Authority voluntarily agreed to add to the wet testing to the permit requirements to confirm that the discharge would not be harmful to marine life. Port Authority has agreed to chemical analysis of the outfall within 60 days of the initial discharge for 71 toxic pollutants listed in the Texas Surface Water Quality Standards. On remand, the Port Authority will provide additional modeling information and work with the staff of the TCEQ to supply additional data that it believes will confirm the testimony of the Port Authority's expert witnesses and TCEQ's witnesses that the outfall from the facility meets the Texas Surface Water Quality Standards and is protective of aquatic life and the marine environment. Under 30 TAC Section 80.265, on the motion of any party or on its own motion, the Commission may reopen the record for further proceedings on specific issues in dispute. Case at hand is exactly the type of situation which that section was intended to address. Reopening the evidence on the modeling issues is appropriate because it will allow the concerns of the ALJs to be addressed and the permit application reevaluated with a relatively small amount of additional work when compared to the time and effort that has already been expended. The remand will avoid the waste of the significant public resources that have already been invested in seeking to obtain the TPDES permit, and the remand will avoid a significant delay in obtaining potable water. In prior briefing, arguments were raised that the remand should not be granted because it would be unfair or inequitable to do so. In fact, the equities favor the Port Authority's efforts to obtain fresh, clean drinking water for the residents, communities, and the region where it serves. The Port Authority is attempting to follow the instruction from the Texas Legislature that every effort must be made to secure and develop plentiful and cost-effective water supply to meet the ever-increasing demand for water, and that in this state, marine seawater is a potential new source of water for drinking and other beneficial uses. The Texas legislature set the equities that apply to this contested case hearing and the motion to remand, and those equities fall squarely in favor of granting the executive director's motion to remand to permit the Port Authority to continue its efforts to ensure that necessary water supplies are made available to the people and industry the port serves. Equities do not support denying the motion so that efforts to obtain plentiful and cost-effective water supplies are delayed, perhaps for years. Protestants have argued that the expense of this matter is a burden on taxpayers and the TCEQ. Protestants' concerns about the taxpayers' expense rings hollow. Those who oppose the remand have made it clear in public statements that they will oppose any and all of the Port Authority's projects and developments in the Corpus Christi Ship Channel. The TCEQ Executive Director and the Port Authority make this request for remand because doing so is the most efficient path forward for the public good as defined by the Texas legislature. Port Authority of Corpus Christi respectfully requests that the commissioners grant the executive director's motion to remand this matter to take additional evidence regarding the depth, modeling, and other referred issues that rely on the model.
Thank you, Mr. Woodring. And do I understand that you're going to reserve the remainder of your time for rebuttal?
That's correct.
Thank you. Colleagues, I'm directing a little traffic here. We have Representative Tinderholt available to address the commission on Old Business 1, and since he has a difficult schedule, I want to try to accommodate him. So let's pause here, and we'll have our general counsel call the caption for Old Business 1. We'll hear from the representative. Then we'll return to this item 2 and take that opportunity to pose any questions that we may have for Mr. Woodring at this point. Ms. Smith, would you call Old Business 1, and we'll give the representative an opportunity to speak?
Old Business 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Bosky Solutions, LLC for air quality standard permit for a concrete batch plant registration number 152013. As a courtesy, the Commission customarily allows statewide elected officials and members of Congress and the Texas legislature to address the Commission on items. However, the Commission may not consider these comments in the deliberations pursuant to Texas Government Code Section 2001.141, which requires the Commission to limit its consideration of any application to the evidence and matters that are officially noticed.
Good morning, Representative Tinderholt. How are you this morning, sir?
Good morning. I appreciate you guys letting me come and speak. I'm going to try to be brief. We got to get to the House floor and vote, but I felt compelled to come and talk about it. This butts right up to my district, and I've been tracking this and watching the video of the different meetings you've had, so I've kind of laid some stuff out to keep myself focused. So I'm going to kind of read some things that I've drafted. It normally goes better that way, and it'll go quicker. If you guys are okay with that.
I do the same thing. Thank you. Go ahead when you're ready, sir.
Absolutely. So, the TCEQ mission statement includes protecting state public health. Your agency philosophy is to base decisions on law and sound science, to ensure that regulations are necessary and effective and current, and to apply these regulations clearly and consistently. This is something that I'm confident you all that are sitting there, you all know this. But I restate them as a reminder as I go through my brief discussion this morning, stuff that you guys probably know better than I do. I believe you are followers of law and order, policies, procedures, and rules, specifically the rules that TCEQ creates for themselves. The evidence, I believe, in this case already shows that according to law, your own rules and the direction from the SOA judge that you must vote to deny this permit. During the April 14th meeting, the Commission discussed remanding the case back to SOA again. Sadly, I went and watched these videos, and I know that sounds pretty boring, but I knew I was going to talk on this, so I went and did a little bit of research. The judge made a ruling. The evidence has been readily provided and available with expert witness documents. Kicking the can down the road, I think, is clearly the wrong answer today. I watched as you complimented the attorney for good lawyering by showing that silica sand is indeed a significant component, and it's not included in this permit. Nor did they check the right box to allow city officials the opportunity to discuss the plant. We don't know whether it was purposeful or not, but it doesn't matter. The law and your own rules are clear, and the city officials must have the opportunity to weigh in. I'm curious what the commission meant when they stated April 14th that you're trying to find a clear path forward. Yet a clear path forward's already been charted by the SOA judge, the law, and your own rules. Silica is an undeniable component of air pollution from this plant. It will not and cannot be controlled to levels permitted by the EPA, which is absolutely zero. This fact alone warrants a permit denial. This has been ongoing for 3 years. The impartial judge spoke, as does the law and TCEQ rules, which are created by TCEQ. The question in front of you today is, are you here to protect TCEQ or to protect the citizens of Texas? I believe that you're going to make the right answer. I believe that your purpose is to not manipulate the rules and not punt the decision to SOA again. The evidence has been laid out. A denial of the permit, I believe, is the only answer. I implore you to uphold the law, your own rules, and the direction of the SOA judge. I'm imploring you to deny this permit and not to approve it and not to kick the can down the road by sending it back to a SOA judge. I understand this puts you in a so-called pickle. I get it, because there's a lot of other plants out there. But just as you can't consider the health of the people that live around the area, you can't consider all of the things that the individual has done with other permits, I believe that it's the same instance here where you have to look and deny this permit. And I think it's super, super important that you deny this permit today. I'm imploring you. I can't use any more important words than imploring you. There's hundreds of people that are counting on this, hundreds of them. And the pickle that this might put you in is the same instance that you can't consider those other folks. I don't think you should be able to even consider what the impact of this will be on 800 or 1,000 or 1,200 other plants. This case is unique to itself, and the rules, laws, and the SOA judge speak for themselves. And I appreciate you guys allowing me today to speak to you. I perfectly understand that it's not something that's considered, but I really wanted to speak up on behalf of the people of the area there that this will impact. And I thank you very, very much. It was very kind of you to allow me to speak today. Thank you so much.
Well, thank you very much, Representative Tinderholt. We appreciate your comments and appreciate you taking time away from your schedule. I know this is a crazy time of the season, the legislative season for you. So thank you so much for being with us.
Absolutely. You guys have a wonderful day, and I'm hoping that this goes with law and order and the SOA judge and the rules. So thank you guys, and have a wonderful day.
Thank you, sir. Let me check now to see if Representative Cook is on the line. Representative Cook, are you there? All right, I don't believe Representative Cook is able to be with us here. So,
Chairman, I understand from our chief clerk's office that he may be on the line. Do you want to give him just one more second in case he's having trouble with the line?
Thank you. Representative Cook, are you able to hear me? I am unable to hear you if you're speaking.
I believe they're still working with him.
Okay.
I understand he's going to call in and try on a different line.
Okay. Well, we'll just hang tight for a moment. Ms. Smith, how are we doing?
Still don't see him on the list of attendees yet. But we might just try addressing him one more time.
Representative Cook, are you there, sir? All right. Well, I do hate to chop up the presentation of these items. Give him one last shot. Representative Cook, are you there?
Chairman, if you want to move on, our chief clerk's office will continue to work with him to get him on the line.
Sounds good. Let's return to item 2. Mr. Woodring, I'm glad you were able to finish your presentation. Let me check in to see if either of my colleagues have any questions for you at this point. I do not. Commissioner Lindley, any questions for Mr. Woodring?
I do not. Thank you.
Commissioner Janeka?
Likewise, I don't at this time. Thanks.
Okay. All right, let's pause there. Representative Cook, are you on the line? All right. On item 2, let's take the protestant's presentation at this point. Mr. Bennett, are you there, sir?
Yes, I'm here. Can you hear me okay?
Loud and clear. Thank you. Go ahead when you're ready.
Okay, thank you. Good morning, Mr. Chairman, Commissioners, General Counsel. My name is Craig Bennett. I'm with the law firm of Jackson Walker, and I represent Port Aransas Conservancy, one of the protestants in this case. Now, I know every case is difficult, but I believe the decision here is clear. This is not a case where landowners are simply asserting not in my backyard complaints, or where the applicant failed to comply with a small technical detail. No, this is a case where the leading aquatic life experts agree that the site of this proposed discharge is a terrible idea. These scientists from the University of Texas Marine Science Institute and Texas A&M Corpus Christi testified that the proposed location for the discharge from this desalination facility is the worst possible place to put it along the Texas coast. Not one, but 2 administrative law judges recognize the potential harm from this facility, and they have recommended that this permit be denied. Those judges agree with the protestants on 6 of the 9 referred issues. Not just 1 or 2 issues, but on 6 of the 9 referred issues, the judges found against the port. Your own executive director also now agrees that this permit cannot be issued on the record before you. So really, the only question before you now is whether you remand this application or deny it outright. I believe the record clearly demonstrates that you should deny it outright, because the ultimate problem with this application cannot be fixed on remand. Namely, the port would have to move the discharge location from the Aransas Pass into the Gulf of Mexico to alleviate the potential harm from the facility. Now, the port already moved the intake location out into the Gulf because of concerns regarding the impact on aquatic life, and it would have to also move the discharge location as well. Unless it does that, a remand does absolutely nothing to fix the biggest problem with this application. Now, just a few years ago, in the Altair case, which is docket number 2018-0013 IHW, the executive director recommended a remand. But you recognized that a remand was not appropriate in similar circumstance, and you denied the permit outright. You should do the same today. This case reminds me of an electric transmission utility line case from a few years ago, in which an electric utility wanted to place a transmission line across a portion of Palo Duro Canyon. Now, the Public Utility Commission rejected that proposal, of course, because it was a terrible idea to have a transmission line across one of our valued state treasures. Similarly, the port's proposal here is a terrible idea. The Aransas Inlet provides the main corridor for larvae to get from spawning grounds in the Gulf to nursery grounds in the inner bay. And the port wants to discharge hypersaline wastewater containing twice the salt content of the ambient water in the Aransas Pass directly into the heart of that corridor. I present a map showing the location of the proposed discharge for your benefit, so you can see exactly what I'm talking about. This location is like permitting a toxic waste dump on Interstate 35 in downtown Austin. It's an idea that should be rejected out of hand. To be clear, though, this case is not about opposition to desalination plants. Desalination is a valuable technology serving a good purpose. But in seeking to permit the first desalination plant in the state, the port has chosen a horrible location. It's one that the director of the Coastal Fisheries Research Program at the University of Texas Marine Science Institute called, quote, literally the worst possible location, end quote. Another expert, Dr. Greg Stuns, the director of the Center for Sportfish Science and Conservation at the Hart Research Institute at Texas A&M Corpus Christi, said this about it, quote, if I had to choose the absolute worst location on the Texas coast from an ecological perspective to place a desalination plant, I would choose Harbor Island in the Aransas Pass Inlet, end quote. Dr. Stuns went on to state that, quote, discharging 96 million gallons a day into the heart of this ecosystem would, in my opinion, be catastrophic, end quote. Now, scientists are not usually prone to hyperbole. And Dr. Stuns, by the way, is the only witness in this case with prior experience evaluating the virtues of a location for a desalination plant. He was hired by the city of Corpus Christi to perform a siting analysis for such a plant, and he was responsible for assessing locations for the discharge of brine from such a plant. He testified that Harbor Island was not even given serious consideration by the city of Corpus Christi because there are so many better alternatives with less adverse impact. Now, the Texas Parks and Wildlife Department and the General Land Office issued a report specifically identifying appropriate locations for desalination plants on the Texas coast. That report says almost the entire Texas coast is appropriate, but specifically excluded 5 places, one of which is exactly where the port wants to put the plant in this case. Now, the port will tell you that report was prepared for expedited permitting only, but that misses the point entirely. The whole purpose of the report was to determine appropriate locations for desalination activities, so the expedited permitting process could be used for those locations. Now, TCEQ's own preamble to its rules under Chapter 18 of the Texas Water Code recognized this purpose, stating, quote, House Bill 2031 required the Texas Parks and Wildlife Department and the Texas General Land Office to conduct a study to identify zones in the Gulf of Mexico that are appropriate for the diversion of marine seawater and the discharge of waste resulting from the desalination process, end quote. Therefore, even you, TCEQ commissioners, have recognized the purpose of the report is to determine appropriate locations for desalination activity. So it is sadly ironic that the port has chosen one of the few places excluded by the report for such activity. Not only that, but the location the port has chosen is directly adjacent to the Redfish Bay State Scientific Area. So not only is it a terrible location from an aquatic life standpoint, it's also immediately adjacent to a state scientific area. It's almost as if the port's criteria was to find the worst possible place for a desalination plant. 6 different experts from a variety of backgrounds, academics who study the marine environment for a living, researchers, former regulatory staff for the TCEQ's predecessor agency, all testified against this permit. These are well-respected scientific minds. They're not consultants hired to support a specific position. Even before they were retained by PAC, 4 of these experts expressed serious concerns about the location of the proposed facility. They did so not because they had an axe to grind or were paid to take a position, but simply because they are marine ecologists with years of work studying the systems involved and who understand the highly sensitive ecology in this area. Now, the port attempts to paint these experts as biased because of their public comments against this proposed facility. But to the contrary, those comments show that these experts actually believe what they are saying. Namely, they understand the harm a desalination plant presents to the sensitive ecology in this area, and they as scientists cannot stand by and do nothing and let a potential ecological disaster occur. So, knowing that this is a highly sensitive ecological area, did the port do a heightened analysis to ensure the protection of aquatic life? No, quite the contrary. This case was referred to SOA in December of 2019. On a draft permit the executive director was ready to approve. Before SOA could hold a preliminary hearing, though, attorneys for Port Aransas Conservancy took the deposition of the executive director's staff witness and demonstrated how the modeling used by the port and reviewed by the executive director was wrong, and the discharge would violate the permit. Because of that deposition, the executive director went back and changed the draft permit. But because staff had no numerical criteria for evaluating the impact of the concentrated brine, the executive director simply loosened the permit limit to allow about 10 times more salinity in the discharge. That is the equivalent of raising the speed limit to whatever speed you intend to drive rather than setting it at a speed determined to be safe. The change did tighten the permit for many pollutants, but not salinity, the main constituent in dispute here. And it's a constituent that could cause tremendous harm to the marine environment and aquatic life. Now, this bears repeating. The ED admitted the modeling error that underpinned its anti-degradation review and the draft permit limits, and soon after, the port also admitted the error. At this point, the public and you would expect that the executive director and the port would have sought to remand the application to reevaluate the impacts of these unexpectedly and dramatically high salinity increases. Instead, the ED simply revised the draft permit limits to allow worse mixing of the salinity and greater risks to larvae and other early life stages of fish and shellfish. Neither the executive director nor the port asked for a remand then, although they clearly should have, given the modeling errors the draft permit was based upon. Now, the expert testimony demonstrates that hypersalinity is lethal to much of the early life stages of aquatic life in the area. And this area is one of the most critical along the Texas coast for commercial, recreational, and sport fishing, representing millions of dollars to the Texas economy. There's no reason to jeopardize that when there are so many other places that could be chosen for desalination activities. Now, the port argues that the hypersaline discharge is of no concern because they claim it results in just a 1% increase in salinity in the Corpus Christi ship channel. However, that number is incredibly misleading because it looks at the broader water body, which, by the way, is a completely arbitrary selection, rather than the specific area where the discharge will occur. Now, the discharge will occur in the Aransas Pass Inlet, which is a critical pathway for the migration of the earliest forms of hundreds of species of aquatic life, which literally float on the currents, and they lack the ability to do anything to avoid the discharge. In that location, in the zone of initial dilution and the other mixing zones, the salinity change is not 1%, but greater than 60% at times. That's a level that experts say would be catastrophic to spawning fish populations. Now, I want to briefly turn to the judge's recommendation, and I want to touch on a couple of points. The judges here recommended denial because they found in favor of protesters on 6 of 9 referred issues, all of the most significant issues. Among other things, the judges found, 1, the port had not shown that the proposed discharge will not adversely impact the marine environment, aquatic life, or other wildlife. 2, the port had not shown that the proposed discharge will not adversely impact recreational activities, including commercial fishing or fisheries. 3, the port had not shown that the modeling complies with the applicable regulations to ensure the draft permit is protective of water quality. And 4, the executive director's anti-degradation review is not accurate. Now, ultimately, the port had argued that the judges incorrectly applied the no lethality standard from TCEQ's rules, but all the experts, including 2 of the executive director's witnesses and the port's own expert, testified that the no lethality standard applied. And that standard is set out twice in your rules. The courts have been very clear that it is reversible error for an agency to not follow its own rules. The no lethality standard does apply, and it must be followed. However, even if TCEQ rules did not contain the no lethality standard, the judge's analysis of the 6 issues decided against the port still clearly supports denial of this permit, not a remand. I want to conclude with this. The decision you make today has the potential to dramatically affect one of the treasured bays and coastal economies in Texas. Contrary to the port's assertion, denying this permit does not set a precedent that no discharges from desalination plants can ever be authorized by you. Rather, denying this permit will demonstrate that you believe in sound science and in protecting both the environment and critical economic activities like commercial and sport fishing along the Texas coast. The evidence is clear. This permit must be denied. This location for this discharge is terrible. And ultimately, all the science dictates that this permit should be denied. And remanding it...
That's time.
Fix that. Thank you.
Go ahead and finish up, Mr. Bennett.
Okay, that was my closing. Just a remand will do nothing to fix the discharge location, which has to be moved. Thank you very much.
Mr. Bennett, thank you very much for your presentation. I appreciate that. Colleagues, any questions for Mr. Bennett? Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
Not at this time, thanks.
Thank you. Colleagues, I'm sorry to keep doing this, but let me pause on item 2 for now and see if we have Representative Cook available to address the commission on old business item 1. Representative Cook, are you there?
Yes, sir. I'm finally here.
Oh, good.
And may I read the caption again
Please
to get
do.
us back? Old business 1 is the consideration of the ALJ's proposal for decision and proposed order in Bosque Solutions.
Thank you, Ms. Smith. Representative, go ahead when you're ready, sir.
Well, thank you so much. First of all, I do want to apologize for my tardiness and being technologically just having problems from a technology standpoint this morning. But I don't want to waste any more of your time than necessary. But this is a very important matter, and I do appreciate the commission carrying this matter over from last month and just giving it the consideration that it deserves. As you know, the people there in the Mansfield area have came together and on a common purpose and have done a really good job of presenting their case. And so I'll just start off with my remarks. Again, my name is David Cook. I'm a state representative for House District 96. I'm here representing myself and the citizens of House District 96. And then, as stated earlier, this is on old business agenda item 1, TCEQ docket number 2019-0665 AIR, and then SOA docket number 582196473. I'm here today to urge you to accept the Administrative Law Judge's proposal for decision and order and deny Bosque Solutions LLC's application for a concrete batch plant standard permit. In Judge Summer Hayes' proposal for decision, she ruled that evidence showed that Bosque's application did not meet the applicable statutory and regulatory requirements for issuance of the permit for this plant. In her proposal for decision, Judge Summer Hayes determined the following: that an application for a standard permit must meet the requirements set out in the standard permit unless otherwise specified by the standard permit according to Section 30 of the Texas Administrative Code, specifically Section 116.6110A1. The standard permit required the application to demonstrate that it meets emissions limitation in 30 TAC, Section 106.261, and by reference, Section 106.262. Bosque failed to demonstrate that the plant will be constructed and operated in accordance with the emission limitations of 30 TAC 106.261 and by reference 106.262. Based on her findings and conclusions of law, Judge Summer Hayes determined that the application fails to meet the requirements applicable to the air quality standard permit for concrete batch plant. And so I simply ask you to follow the work that Judge Summer Hayes has put in on this matter. It seems as if there's a hesitancy from the commission about potential bad precedents. I know that there's been some media involved in this, and it just seems like there's a hesitancy from the commission's perspective with regard to a law that was regulations that were amended back in 2012, and obviously that was before these commissioners' time. And I would simply just ask if you take the law as it is. It's been there since 2012. That is a case precedent in and of itself. And I would ask that if the commission elects to change this in the future, that affects future applications, not the one that we're here about this morning. Concerns about prior permits that have been granted over objections but are not appealed should not be irrelevant to the subject case. Sending this case back to the SOA is the wrong thing to do. I'm very concerned that the rules will change and wrongfully impact this case if this matter is sent back to SOA. I ask that you make the decision based on the hard work that was put in by Judge Summer Hayes, and that you make the decision based upon what's been presented to you. Commissioners, I implore each and every one of you on behalf of each protestant and family that will be negatively impacted by this proposed project to make your decision on what is in front of you currently. The facts are simple. Prior to filing his air quality permit, businessman John Sheffield failed to do any testing. In fact, his attorney told each of you last month that the application did not require the testing under TCEQ regulations, and obviously we know that that's incorrect. Please review this matter under a no evidence motion for summary judgment standard. I know that's it's a legal term, but what I mean by that is simply that there is no evidence here because they performed no testing. That's what's before you, commissioners, and I would ask that you make a decision based upon that. Due to the applicant's failure to do the testing, it renders the application completely unable to inform the public and the commission as to the levels of cement dust that would be included in the over 13.5 tons per year of emissions. I respectfully request that you make your decision based on this point and deny this permit. Please do not change the rules on these homeowners at this point in their 3+ year journey of protecting their homes and their livelihoods by referring this matter back to SOA. The case must be decided from the laws and science that were in effect and available in August of 2020 when Judge Summer Hayes conducted a full and fair hearing in accordance with the laws of the state of Texas, including the existing regulations of TCEQ. That's the fair thing to do, and it's the right thing to do in denying this application. Commissioners, again, first of all, I want to say thank you for allowing me to speak later in the agenda. I do apologize. In my starting, Governor Abbott requested our presence this morning, and so I do apologize to each of you for being late, but I simply ask you to follow the hard work that's been put forth by Judge Summerhay and do what's right for these homeowners and deny the requested permit in this matter. So thank you again for your time, and I'll yield at this point.
Representative Cook, thank you very much for being with us this morning, taking the time out and sharing your thoughts and your comments with us. And believe me, I'm very sympathetic when it comes to technological problems. It's a miracle that I've been able to make all these commission meetings myself, but I'm glad we were able to connect with you.
Well, thank you again for the assistance in getting on and listening to my remarks this morning. I appreciate what you do, and I know this is a tough decision for each of y'all. So you'll be in my prayers, and just do the right thing in this situation. Thank you very much.
Thank you, sir. Colleagues, let's return to item 2, and Ms. Smith, just so reminding our P's and Q's, I'll have you read the caption again, please.
Item number 2 is the consideration of the ALJ's PFD and proposed order concerning the application by the Port of Corpus Christi Authority for a TPDS permit.
Thank you, Ms. Smith. And colleagues and parties, again, I apologize for chopping up the presentation on item 2. This is just a difficult time. We want to hear from our elected representatives, and it's hard to do that during the legislative session. So I'm glad we could fit all that in. Next up is the presentation by the Executive Director, and I'll ask you to identify yourself and go ahead when you're ready.
Good morning. I am Kathy Humphreys with the Water Quality Division. I'm sorry. Let me start over. I'm Kathy Humphreys with the Environmental Law Division. With me today are Peter Schaefer, Shannon Gibson, and Katie Cunningham of the Water Quality Division. I'm going to limit my remarks to 3 specific topics: the Executive Director's request for remand, concerns over potential toxicity, and the appropriate use of the Texas Parks and Wildlife General Land Office study. First, the Executive Director's request for remand. Following our standard practice, the Executive Director used the Cormix model to evaluate the Port of Corpus Christi's proposed discharge. The depth of the diffuser is a critical input to the Cormix model used by staff to determine the effluent percentages at the boundaries of the regulatory mixing zones. The effluent percentages predicted by the Cormix model are used to establish water quality-based effluent limits, biomonitoring parameters, and in the anti-degradation review. During the course of the administrative hearing, the Executive Director learned that the diffuser would be located at a depth of approximately 90 feet rather than 63 feet, as represented in the application. Also, during the hearing, there was discussion about the Executive Director's use of default ambient velocity value rather than a site-specific ambient velocity. Because of this new information, the Executive Director respectfully requests the Commission remand this application to SOA to take additional evidence on the ambient velocity, actual depth, and slope of the channel at the proposed diffuser location, and for additional consideration of the other issues that rely on the Cormix model. To ensure the draft permit complies with all applicable regulatory requirements, after the model is rerun with new inputs, other water quality permitting staff will need to evaluate the impact of the model results on the anti-degradation review, standards review, and the draft permit. These reviews correlate with referred issues: A, whether the proposed discharge will adversely impact the marine environment, aquatic life and wildlife, including birds and endangered or threatened species, spawning eggs or larval migration. Issue C, whether the proposed discharge will adversely impact recreational activities, commercial fishing or fisheries in Corpus Christi Bay and the Ship Channel. D, whether the application and representatives therein are complete and accurate. G, whether the modeling complies with applicable regulations to ensure the draft permit is protective of water quality, including using accurate inputs. H, whether the Executive Director's anti-degradation review is accurate. And I, whether the draft permit includes all necessary and appropriate requirements. Additionally, the executive director recommends that the duration of the hearing on remand be 120 days from the date of the preliminary hearing to the issuance of the administrative law judge's proposal for decision. The next issue I will address is the potential for toxicity from the Port of Corpus Christi's discharge. In addition to remanding the application to SOA for additional evidence, the executive director respectfully requests the commission find that any potential toxicity in the Port of Corpus Christi discharge will be addressed through whole effluent toxicity testing. It is important to note that based on the requirements in 30 TAC section 307.6E and the threshold criteria established in the 2010 implementation procedures, a whole effluent toxicity review, also referred to as a biomonitoring review, was not required for the Port of Corpus Christi's proposed discharge. However, based on public comment, the Port of Corpus Christi voluntarily to include biomonitoring requirements in the draft permit. The draft permit includes requirements for both 24-hour acute wet testing and 48-hour wet testing. The purpose of biomonitoring is to directly measure the aggregate toxic effects in terms of lethality and sublethality on sensitive surrogate species, including vertebrates and invertebrates, when exposed to effluent at the critical dilution of the receiving waters. More simply put, biomonitoring evaluates the effect of the discharge on test species. The last issue I will address is the importance of the Texas Parks and Wildlife General Land Office study. This study was required by HB 2031 from the 84th Legislature, which created new Texas Water Code Chapter 18 relating to marine seawater desalination projects. Section 18005E requires the TCEQ to provide an expedited procedure for acting on an application. 18005G requires that the Texas Parks and Wildlife Department and the Texas General Land Office recommend discharge zones where permittees with permits issued under Chapter 18 are authorized to discharge. Chapter 18 does not limit discharges permitted under Chapter 26 to the discharge zones described in the study. Thus, the study should not be used to evaluate applications submitted under Chapter 26. Because the application for the Port of Corpus Christi was submitted under Chapter 26, the location restrictions in Chapter 18 do not apply to the application and should not have been considered as conclusive by the administrative judge. Thank you, and we are available for questions.
Thank you, Ms. Humphreys. I appreciate the presentation. I don't have any questions at this point. Colleagues, any questions or comments? Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
I think I have one question I'd like to try to start to carve into with ED staff while we have them available right now. Ms. Humphreys, I'm just curious, could you comment at all on what extent the wet testing may inform agency staff about the degree of lethality that or toxicity that it may pose, the discharge from this permit application may pose for, you mentioned it will measure lethality for vertebrates and invertebrates. I'm curious, does this capture the larval life cycle stage of the fish that the aquatic life forms that were of such interest in this item in the discussion at SOA?
Commissioner Jenica, I think this would best be addressed by Peter Schaefer of the Water Quality Division.
Hi, Commissioners, Chairman. This is Peter Schaefer of the Water Quality Division. Our biomonitoring testing requirements in this permit are twofold. There's a 24-hour acute biomonitoring test and a 48-hour acute biomonitoring test. Now, these tests are just looking at lethality. They're not looking at growth and reproduction. That would be a chronic aquatic, toxicity test.
Mr. Schaefer, let me just add maybe a clarifying question. Lethality, does it consider lethality to life in the larval stage? or is it all stages, or just adult stages, or how is that done?
In this case, it is adult stages. It is the test species are the mysid shrimp and the inland silverside.
Okay, I appreciate that. Commissioner Janeka, did that answer your question?
It did. Thank you.
And may I remind the commission that because this is oral argument and not an opportunity to testify, we probably should stick to responses from counsel based on the record.
Thank you, Ms. Smith. That's an appropriate admonition. We all appreciate it. Colleagues, any other questions for staff at this point? All right, let's turn to the Office of Public Interest Counsel. Mr. Wayne, are you with us this morning?
Hey, good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, Attorneys, and staff. I am Sheldon Wayne with the Office of Public Interest Counsel. And after considering all of the evidence and the argument that's been presented in this matter, including all post-hearing filings, OPIC urges the position that was taken in our closing argument, that the Port of Corpus Christi Authority's application should be denied. And further, we do not support a remand to SOA to take additional evidence. If approved, this proposed desalination plant will discharge a high salinity effluent into the Corpus Christi ship channel near the confluence of the Corpus Christi Channel, the Lydia Ann Channel, and the Aransas Pass Inlet. This inlet connects the Aransas Bay with the Gulf of Mexico, and it's the only tidal inlet in the area. It is a region that is home to important aquatic species at the most vulnerable times in their lives, namely their larval stages. In light of the vital importance of the spawning ground and the larval migratory route that could potentially be affected by the proposed discharge, this application does merit a high degree of scrutiny. This is a highly complex application, and the contested case featured 9 referred issues. Therefore, I will use my time to comment on the most disputed issues. Regarding the legal standard for evaluating the impact to aquatic organisms, OPIC agrees with the administrative law judges that based upon the plain language of the rules, the no lethality standard that's contained in Title 30 of the Texas Administrative Code, Section 307.8b2, is the correct standard. The standard is contained in TCEQ's rule applying Texas surface water quality standards, and it is entitled Application of Standards. It does not contain any exceptions, and it specifically applies to mixing zones. It states that acute criteria and acute total toxicity levels may be exceeded in small zones of initial dilution at discharge points of permitted discharges, but importantly, there must be no lethality to aquatic organisms that move through a zone of initial dilution. Expert witnesses, including the Port Aransas Conservancy's witness, Dr. Andrew Espa, the Executive Director's witness, Dr. Mary Ann Wallace, and the Port Authority's own witness, Dr. Leal Tischler, all agreed and confirmed that TCEQ's rules prohibit any lethality within that zone of initial dilution. The alternative no significant lethality standard contained in Section 307.6E1 that's been advocated by the Executive Director and the applicant applies only to measuring the impacts to aquatic organisms when conducting biomonitoring of effluent samples under the specific guidelines applicable to whole effluent, which is also known as wet testing. It does not apply to evaluating impacts to organisms that are actually traveling through the zone of initial dilution. There are obviously 2 standards here. The biomonitoring required by wet testing evaluates acute toxicity to aquatic organisms over an extended period of time. It makes sense that over a longer period of time, exposure could result in some deaths of aquatic organisms, as long as there's no significant lethality. In contrast, while aquatic organisms are exposed for a much shorter period of time while actually traveling through the zone of initial dilution, there should be no lethality. Additionally, application of the no lethality standard results in a harmonious reading of the rules, and one that ensures all words are given effect. If the no significant lethality standard were to apply as broadly as recommended by the Executive Director and applicant, Rule 307.8b2's express requirement that no lethality occur in the zone of initial dilution would be rendered meaningless, an outcome that should be avoided if possible. Now, regarding the modeling that was performed and relevant to a number of issues, the administrative law judges found that there were many shortcomings in the core mix modeling. Among other things, it utilized inaccurate and unrepresentative bathymetry and ambient water velocity data, a diffuser design that will not achieve permit limits, and ignored the presence of an eddy and resulting hole located directly at the proposed diffuser's location. Because the model used these inaccurate inputs, the results it produced provide no assurance that the draft permit is protective of water quality. Regarding issue A, OPIC agrees with the administrative law judges that the port failed to carry its burden in proving that the discharge will not adversely impact aquatic life. Protestants presented compelling evidence that a vast number of larvae are likely to be adversely affected and indeed killed because they lack the ability to swim and the currents will carry them through the mixing zones, including the zone of initial dilution. The port did not rebut this evidence with any convincing showing that the larvae would not suffer lethal effects. And as previously discussed, the Texas surface water quality standards require that there be no lethality to organisms that move through that zone of initial dilution. Regarding issue C, OPIC agrees with the ALJs that adverse effects to larval organisms could cascade and cause harm to fisheries and commercial recreational fishing. Regarding issue D, OPIC agrees with the ALJs that the application is not complete and accurate. In addition to the errors related to the core mix modeling previously discussed, the application inaccurately identifies the diffuser height and channel depth at the location of the outfall. Regarding issue H, OPIC agrees with the ALJs that the anti-degradation review was not accurate and did not ensure that the discharge complies with substantive anti-degradation standards. Regarding issue I, OPIC is respectfully recommending denial of the permit, but if the Commission disagrees and is inclined to issue the draft permit, OPIC maintains its position that it does not include all appropriate necessary requirements. Among other things, the description of the zone of initial dilution is ambiguous, and it would be reasonable to include a 6-month deadline for completion of the ambient water velocity study. Finally, regarding the Executive Director's currently pending motion to remand, OPIC takes the position that remand is inappropriate. The equities here favor denial of the permit. Remand is sought in part to evaluate the effects of an eddy in a hole that increased the depth of the channel bottom at the discharge location from the 63 feet, as identified in the application, to 90 feet. However, this hole has existed for many years and has been identified in Army Corps of Engineers surveys since at least 2011. The port chose to ignore these characteristics of the discharge location and instead submitted and continues to defend a materially inaccurate application, inaccuracies which the protestants have identified, and which has already resulted in revision of the draft permit after this matter was referred to SOA. The protestants have expended considerable resources litigating this matter, and under these circumstances, it would be unfair to allow the port another opportunity to meet its burden on this application. Additionally, OPIC notes that at any point prior to the issuance of the proposal for decision, the port could have explored withdrawing its application without prejudice, which would have allowed it to correct and resubmit. This course of action would have conserved all parties' resources, including those of the TCEQ and SOA. Instead, the port elected to proceed with the contested case hearing process and see this matter to its conclusion. Considering all of this, it seems appropriate to OPIC that the applicant be held to that choice. It is for these reasons that OPIC respectfully recommends denial of the motion to remand. OPIC further recommends the Commission adopt the ALJ's proposal for decision and deny this application. Finally, OPIC recommends the Commission sustain and incorporate the proposed changes as set out in the ALJ's reply letter. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I appreciate your presentation. I have none. Colleagues, any questions or comments? Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
Thank you.
Thank you. And Mr. Wootring, you have 4 minutes for rebuttal, sir.
Thank you. Good morning. Let me hit on some of the more important points that were just addressed. First, the Port Authority is trying to carry out its local government function to address the important interests of the 400,000 plus residents in Nueces and San Patricio counties, and to make every effort, as the Texas legislature directed, to secure and develop plentiful and cost-effective water supplies to meet the ever-increasing demand for water. There is no local government, no other persons opposing the Port Authority's efforts except for one nonprofit and a handful of individuals. With regard to statements from the protestants that this is not a matter of not being in their backyard, their own expert, who was referred to today, said, and I'm quoting, "I probably should not say it out loud, but I too am biased in my opinion about this facility. If nothing else, I just don't want the damn thing built here." With regard to the location of the facility, it is appropriate. The evidence in the record establishes that because of the enormous tidal activity in the area, that means that the 95 million gallons per day will be diluted to no more than 1/2 of 1 percentage point of the total tidal volume in the area of discharge. 1/2 of 1%. Claims about being in the wrong location are not supported by any specific data, but by the protestants' experts who have not provided a reliable basis for those opinions, or, as the protestants admitted in their briefing, their experts have made clear that specific data is not necessary for their opinions as to some of the deficiencies they identify. They have provided qualitative opinions not supported by data and that would not be admissible in any civil court in the state of Texas. Let me reserve a fair amount of time here to make sure that the commissioners understand not only the Port Authority's view, but also the executive director's review on the interpretation of whether there is a no lethality standard in the zone of initial dilution or no substantial standard. According to the executive director, if the commissioners sign off on the proposal for decision, conclusion of law number 10, then it would mean that if any organism were to die in the boundaries of the ZID, regardless of the circumstances, such an instance would be impermissible under Texas law. Under this interpretation, even single-celled organisms such as phytoplankton that are caught in the turbulence and subsequently die will present a fatal flaw in every TPDES permit. Such a conclusion is illogical in an ecosystem that functions under typical biological processes, even if the effluent flow were simply redirected to Indian Channel water. In our view, if the commissioners were to sign off on conclusion of law number 10, it would have a vast and negative impact not only on this permit, but hundreds of existing and proposed permits and proposed permits. The Port Authority has been and is willing to consider any and all improvements to the permit to permit and everyone to understand that it is protective of marine life and the environment, including enhancements to wet testing or other permit requirements. We want the opportunity to carry out the legislature's commandment that we make every effort to provide drinking water for the people in the area that the port serves.
That's time.
Thank you, Mr. Wootring. Colleagues, any questions for Mr. Wootring?
Name.
Commissioner Janeka?
I don't think so. Thank you.
Thank you. I do have a question. I'm not sure if they'll have an answer for both Mr. Bennett and Mr. Wayne. I'll begin with Mr. Bennett. Same question, and that is, we just heard that Mr. Wootring's view that accepting conclusion of law 10, we're talking about the standard for lethality in the ZID. His reading is that any death in the ZID would be impermissible, even a single cell organism. And I wanted to get your reaction to that, beginning with you, Mr. Bennett, whether you think that's a correct understanding or what your view is generally, or perhaps if you haven't formed a view about it. But Mr. Bennett, go ahead when you're ready.
Yeah, I think that it's a difficult question to answer because I think it becomes very fact-specific, meaning looking at what are we talking about in a particular case. Ultimately, I think one of the problems here is we're not talking about a single-cell organism. We're talking about fish larvae that are clearly significant. To the extent that you want to interpret the no lethality to apply not to single-cell organisms, there may be some room for that. I don't know the scientific basis. I think there'd have to be some evaluation. Clearly, there was a reason that the commission adopted that language in their rules, and it's there. And whether, partially what's important to note is that's in the rules regardless. I mean, whether it applies to other sorts of constituents, whether it applies to salinity, it's there. It's not just something that would apply to desalination. it's something in your rules that applies to, a number of different things related to water discharge. And so ultimately, yes, you have to wrestle with how that applies. I think certainly it applies to larvae, which are, significant to the growth of adult fish populations. They're the underpinning of it. Single cell organisms, I don't know. I guess we would have to factually look at the specifics of a case. I certainly don't think that the adoption of the no lethality standard, which again has already been adopted in your rules, would be the death knell for desalination or any other wastewater permits. So I guess I'm not sure I can answer that, because I think it's a very scientific and fact-based inquiry that goes into each case, depending on what sort of organisms we're talking about.
Thank you, Mr. Bennett. Mr. Wayne, let me put the same question to you and this is really a question of legal interpretation. How does the Office of Public Interest view this as a statement of law, if I can frame it that way? And it's whether it's correct that any death in the zone of initial dilution is impermissible, including even the death of a single cell organism. If you have a reaction to that, go ahead.
Absolutely, and thank you, Chairman. What OPIC really rested the basis for our position on was the plain language of the rule. The rule says that there is no lethality should occur, and we think that that's a workable rule. It's been in the Texas Administrative Code and in effect for many years, and that same language appears in multiple places. In addition to 307.8b2, it also appears in 307.6, and I believe that it appears in, I apologize, I am grappling for that exact citation. In 307.6b6, I believe it appears as well. It's unknown why that standard would be workable in some circumstances, but not others, as advocated by the executive director and the port. And here, really, it's a matter of the location that was chosen. The port has chosen a location that's home to many vulnerable organisms at, indeed, the most vulnerable stage of their lives. If a different location was chosen, we think that the circumstances would be materially different, and there wouldn't be near as much of a concern, or the concern would certainly be lessened, if not minimized or reduced entirely, that organisms would not suffer lethal effects. We think that could be achieved easily in a different location, and simply because of the extremely sensitive nature of this location that the port has such trouble making that showing. I do think that it would be a little bit illogical and to apply this same line of reasoning all the way out to single-celled organisms. I don't believe that the commission even considers single-celled organisms, but I'm not a technical expert, so I believe that would be an absurd result, and that would be, my kind of legal reasoning on that on the spot.
Thank you, Mr. Wayne. I appreciate it, and I'm sorry to Mr. Bennett, sorry to put you both on the spot, but Mr. Wittering raised the issue. I was curious about it, so I do appreciate you taking a stab at an answer.
No apology necessary. Wish I had formulated a slightly better answer for you folks.
Well, you can't anticipate every question you might get, but thank you for that. Colleagues, any questions for any of the parties at this point?
No questions. I thought that was a great question, and appreciate both gentlemen responding.
Thank you, Commissioner Lindley. Commissioner Janeka?
I just really can't help but want to ask the question because it seems so simple and obvious to me. I think this would be best directed to Mr. Wittering, and it simply goes to the helping me understand so that I can help explain to the public when inevitable intense focus and attention continues on this new area of our state's search for water for the public, and that is simply, has your client looked into and given an explanation, and I'm not sure that it really bore out very explicitly or clearly in the record, but what's the answer for why there was a discrepancy between the depth of the bottom at the discharge point of the outfall of approximately 60 feet versus 90 feet?
Because there was a localized eddy that changes the bathymetry at that exact location. In our view, and we think our expert testimony provided this in the record, that eddy and that localized increase in depth enhances the mixing and makes the existing modeling more conservative. The ALJs disagreed, and they wanted more specific data. That's the type of data that we think we can provide that will show that being deeper and having more current enhances the mixing and provides more protection for marine life in the environment. I'm hoping that answers the question. Yes, of course, in retrospect, we provide a much more complete choice of the localized bathymetry in the area to avoid exactly these issues.
I appreciate that. And I wonder, as a final question, if you might respond to the questions that have been raised by the other commenters about your client's decision to continue on and proceed with the application past the point of being made aware of, for instance, that discrepancy in the data in the application versus conflicting data from elsewhere. Could you possibly speak to the, well,
yes.
Would you care to respond to that?
Yes, yes, of course. Happy to have the response to that. Again, for issues like the bathymetry and the tidal ambient velocity and the eddy flow, it was our view that those additional localized factors made the existing modeling more conservative and meant that if you factored those things into the modeling, they would be, you would have enhanced mixing, enhanced solution, and be more protective of the environment, and we believe the administrative record bears that out. But, if the ALJs disagreed with that, that's the kind of things we can provide. If the reason the court continued is because we thought the localized matters made our modeling more conservative, not more risky for the marine environment. And I would say that there is a time component in trying to get a desalinization permit. We understand the process. We also understand the urgency of the need in the area, and backing up and trying to start over is going to take us back at least 2, possibly 3 years. And the Port Authority, as a local government entity, is very concerned about the next drought in which there will be no alternative source of potable water for the people or industry in the area.
Commissioners, may I briefly, this is Craig Bennett on behalf of Port Aransas Conservancy. I would just like to briefly make one quick point, if that's okay, to something Mr. Wotring just said. And that is, ultimately, it would have been very easy for the port to just do alternate modeling. It could have modeled both. So the idea that, oh, well, we just took the conservative approach, so that really falls on deaf ears with me, because it's like, just do both. Have both ready, because you know you're not using accurate data. So to me, that would have been an easy solution, and everybody could have had a hearing evaluating both.
Thank you, Mr. Bennett, and thank you, Mr. Wotring, for your explanation as well. Commissioner Janecka, did that answer your question sufficiently?
No other questions from me at this time. Thank you.
Okay. Well, colleagues, let me share my thinking on this, and just kind of starting at the basics. The legislature created a framework for authorizing desalination facilities that are protective of public health and the environment. And of course, our agency has promulgated implementing regulations, and now we're getting a chance to test those in a first of its kind application. And my observation is things could have gone smoother. Not unexpected that things are bumpy in a first of its kind application, but they could have gone smoother. I do, though, think that the process is working in that the protestants have raised legitimate questions about the protectiveness of the proposed authorization, and now those questions can be addressed. So the ALJ identified several instances in which the applicant failed to meet its burden. They almost all trace back to the inaccurate inputs to the core mix modeling that we've been discussing this morning, specifically the bathymetry and the velocity data. And what I ascertained in preparing for this item today, and what we just heard from the applicant, is that the applicant had an opportunity but did not take the opportunity to correct the inputs on the belief that these were errors on the side of caution. In other words, the applicant thought the errors made the modeling more conservative. We can now all appreciate that that is not an entirely safe assumption. We simply don't know, and so it makes sense to look at that. I mean, it may have been helpful to Mr. Bennett's point to have already done that work. It's not done. I think we do still have an opportunity to do that. And of course, the questions about the core mix inputs have raised questions about the diffuser design, the anti-degradation review, impacts to fisheries, and so on. So I do think we have two paths here. We could accept the protestant's invitation to deny the application, or the executive director's invitation to remand the matter to take additional evidence on the 6 issues that staff identified. And I really do think there are equitable arguments on both sides. I appreciate the burden this matter has already placed on all of the parties, but in my view, the weight of the equities and the better policy is to remand the matter so that we can determine whether the proposed authorization is indeed protective based on more precise data inputs. And so that's what I would propose. I do want to address the standard for lethality in the zone of initial dilution and acknowledge that our rules are indeed ambiguous about whether there should be no lethality or no significant lethality. And in my view, the more permissive rule, that is 307-6E1, is the correct standard. And in part because the more restrictive standards, the no lethality standard in sections 307-8B2 and 307-6C6, those sections apply only to numerical acute criteria for toxic substances, and there's no numerical criteria for salinity or salt. So that, in a nutshell, is how I view that particular legal issue. My view about remand. I do have a motion to that effect that includes instructions on the legal standard and the 6 issues to be remanded, as well as some notes on scheduling with respect to the submission of additional information when the preliminary hearing would occur and when the PFD would be issued. But before I offer that, I would like to get a sense of how you view the matter and whether you have different ideas or reservations about a remand or about my take on the legal standard or anything else. So let me pause there, and Commissioner Lindley, let me ask you for your thoughts.
I'll keep my thoughts pretty brief. I think you addressed most of what I jotted down, essentially saying today. Everyone stated it, the applicant and the protestants, both attorneys for both groups said it, and I do completely agree that there are, that I recognize all the potential positive impacts that desal will have for the state. And this issue is very, very significant for the future of water for our state. And so this one was really tough, mostly for that reason. However, today I'm not in a place where I would feel comfortable granting the permit. And so, like you said, the 2 options are remand or to adopt the PFD. And I'm supportive, and I'm on the same page as I believe a remand is what's most appropriate today and what I'd be comfortable doing. I think I had, I'm guessing our lists are somewhat similar. I would be interested to hear, and we can let Commissioner Janeka talk first, but interested to hear your motion, especially on the lethality, just to make sure I understand it completely. But I think we'll probably come down, I don't know, mostly the same on the issues. But Anyway, I'll stop there. And I'm actually going to turn off my camera for 1 second, but I'm still listening, so I'm not going anywhere.
All right. Thank you, Commissioner Lindley. And just real quickly, my position on the lethality standard is that it should be the standard for non-numeric criteria that's found at section 307.6E1, which is the no significant lethality standard. That's what I would include in my motion. Commissioner Janeka.
Thank you, Chairman. First off, I think I'm in full agreement on the open question between which of those two somewhat ambiguous pathways or which standards would be applicable here. I think that the more permissive of the two, 307.6E1, is the appropriate standard to utilize in this case, given that there is no numerical value for salinity. The other two citations, I think, I agree with you explicitly, refer and apply to constituents for which there are values, but I appreciate you laying out the issue as well, and I think that I'm also prepared to move forward with the remand today, and I think that the issues, to that end, the issues that the executive director staff agreed as appropriate for remand and part of their motion, I think or their filing, I'm in agreement with, and I would merely return back to executive director's comments on the Texas Parks and Wildlife study, and I feel the need to chime in a little bit to say that I appreciate ED staff making a very thorough evaluation of the context from which that study came and from which our agency officially will reference and needs to acknowledge that. But I think I'm in strong agreement with the conclusions of the ALJ in regards to that point, and just wanted to touch on that while we're discussing the host of issues and at the risk of forgetting to come back to this later. So I'll toss in those last 2 cents and just say that I would encourage ED staff to revisit where the ALJ made their findings around that study, and I think that to the extent that the ALJ highlighted that as a piece of valid information to be aware of and to consult in regards to a very sensitive issue, I would encourage ED staff to revisit that in that mindset, because I think that this is a very sensitive issue. And stepping back, bigger issue, bigger picture, this is the first of what we hope will be many desalination facilities across our great state as we continue to grow and have more and more population. And I think it's imperative that we do get it right. And for that reason, I think there's some really compelling public policy goals that are well served in being deliberate in how our agency considers it. And I think it appears to me that the real meat of this question, the technical question, in my mind, the open question is will the release of this particular outfall in a media where the fauna are not mobile themselves necessarily, and they may be moving through the emission source, which I just have to observe is such a unique change of pace for us as an agency. We typically see the fauna ambulatory, and they're able to go around the pollution sources. This is the exact opposite here. But I think that the questions that protestants raise about the demonstration that ED is requiring an applicant is making, even to volunteering, going above and beyond requirements to agree to the whole effluent testing, the biomonitoring, which I appreciate. I think that it comes right up to the edge of the very important issue, which is there an open discrepancy about this permit in this facility? And I think that there is a real public policy, a negative outcome if our agency were to proceed injudiciously too quickly, and that would be if a facility would be cited without that determination being appropriately made. I would hate to see other external factors affecting fish stocks, the Texas maritime economy, fishing industry, for whatever reason. I would hate for a desal facility, the first desal facility in the state, as timing may allow, to be blamed inappropriately or incorrectly as the guilty party in what we're all too used to seeing, a very complex environmental question that's very difficult to answer with any certainty. I think if we don't try our utmost now to answer that question to the best of the ability that we can, or to put in the appropriate question structured into the permit. I think that's a really important public policy outcome to be mindful of. So I think I'm circling around that. I don't know that I have a really very concise point, and I appreciate the time to chime in. Thanks.
Thank you, Commissioner. Yeah, I mean, fundamentally, our job here is, if we issue an authorization, our job is to make sure that that authorization is protective of public health and the environment, and in this case, especially the marine ecosystem. And I think we're all in agreement that the applicant has not yet met its burden of proof on that, and that's really the purpose for the remand. Specifically to the Parks and Wildlife GLO study, since you brought it up, I'll just share my thoughts on this. And it's really, the analysis is really subsumed into that issue A that staff asked for a remand on, and that I would include in a remand motion. So I don't call it out specifically in the motion that I'll read in a moment. But my view of that is it is neither controlling nor is it irrelevant. It's not controlling because it's a feature of our expedited permitting path, not this permitting path. But it's not entirely irrelevant either. I think in my mind what it does is it identifies a sensitive area. And what that means to me is we need to be focused on this and make sure that we are being careful in doing our job of making sure that the permit is protective. I think Mr. Wayne phrased it as making sure that there is an appropriate degree of scrutiny for this application. And that's, to me, that's the relevance of that Parks and GLO study is this is a sensitive area. I don't think there's really a lot of dispute about that. But again, neither controlling nor irrelevant. Well, colleagues, let me do this. Let me go ahead and read a motion, and then invite any additional thoughts or comments. I move that we remand this matter to SOA for the ALJs to 1, apply the appropriate legal standard for non-numeric criteria found in 30 Texas Administrative Code, Section 307.6E1, for evaluating the impacts to aquatic organisms that move through a zone of initial dilution, and 2, take additional evidence on the following issues. A, whether the proposed discharge will adversely impact the marine environment, aquatic life, and wildlife, including birds and endangered or threatened species spawning eggs or larval migration. C, whether the proposed discharge will adversely impact recreational activities, commercial fishing, or fisheries in Corpus Christi Bay and the Ship Channel. D, whether the application and representations contained therein are complete and accurate. G, whether the modeling complies with applicable regulations to ensure the draft permit is protective of water quality, including utilizing accurate inputs. H, whether the executive director's anti-degradation review was accurate. And I, whether the draft permit includes all appropriate and necessary requirements. I further move that we, number 3, set a 30-day deadline from the issuance of the Commission's order for the applicant to provide revised information to all parties, including the depth of the channel, site-specific ambient velocity, and the depth of the diffuser. 4, allow the parties 30 days to review the revised information before setting a preliminary hearing. And 5, set the hearing duration for the proceeding at 120 days from the date of the preliminary hearing on remand to the issuance of the proposal for decision. So that is the end of my motion, and let me pause there and invite any further discussion. Commissioner Janecki, you moved to the left of my screen for some reason, so reading from left to right, let me invite you to go first. Additional thoughts or comments?
Hazards of turning off your camera. I think I'm in agreement with that motion. I'd be prepared to second it if and not seeing any concerned look from Commissioner Lindley, I'll go ahead and second that motion. But getting on to discussion, I'm comfortable with that motion. I do have a question that I would want to just confirm wouldn't pose a logistical concern for the applicant on the 30-day deadline in this proposed motion to provide site-specific ambient velocity. And I think, was that one of the factors that would have been proposed to be studied with OPIC suggested imposing a specific deadline on providing that data? I just would love to make sure that wouldn't pose any problems of setting a 30-day deadline for something that I'd rather get the right value in our model rather than a 30-day value is what I'm trying to suggest here. So if those specific homework items aren't a problem or a concern for the applicant, then I'm perfectly comfortable, and I don't have any other discussion.
Commissioner Janecka, my reading, I can't tell you where this came from in the record. Maybe it was just an imagination or assumption on my part, was that those site-specific velocities were already published and well known, and certainly if they're not, they should be knowable within the 30-day deadline. If they can't be, I think we might have other problems. So I would suggest we give them the opportunity to use their 30 days as they see fit, and either they're able to provide that or they're not, would be my recommendation. That sounds all right.
Well said and agreed.
Okay. Commissioner Lindley, additional thoughts or comments or questions?
No, I would have seconded the motion, so.
Okay, so we have a motion and 2 seconds, which seems better than one. Let me take a vote. Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janecka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, I'll ask you to return us to old business number 1 and call the caption, please.
Old business 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Bosky Solutions, LLC for a concrete patch plant registration number 152013. The ED will be allowed 3 minutes to present its motion to remand. Each party will be allowed 3 minutes to respond to the motion in the following order: applicant, protestants, then OPIC.
Thank you, Ms. Smith. And just a note that we heard earlier from Representatives Tinderholt and Cook on this item, and we had to take things a little bit out of order, but if somebody is reviewing the archives on this, be aware that there's some other discussion on old business item 1 that precedes this discussion. With that, let me turn it over to the Executive Director's staff.
Good morning. Can you hear me?
Good morning, Ms. Browning. Loud and clear. Go ahead.
Thank you. Good morning, Commissioners, General Counsel, Public Interest Counsel. My name is Amy Browning with the Environmental Law Division, representing the Executive Director. With me and available to answer questions are Betsy Pedicolis, also with the Environmental Law Division, and Don Nealon of the Air Permits Division. On April 29th, the Executive Director filed a motion requesting that the Commission remand this matter back to SOA to allow further development of the record relating to the protectiveness of the concrete batch plant standard permit as it relates to the emissions limitations contained in 30 TAC Section 116.610A1. Generally, the only issue to be considered during a contested case hearing is whether the application meets the requirements of the standard permit, and the protectiveness of the standard permit itself is not an issue during the contested case hearing on an application to register for use of that standard permit. However, in this case, the Commissioners have previously indicated that more information in the record that could demonstrate that the standard permit is protective would be useful. The Executive Director is currently engaged in rulemaking to correct the inadvertent removal of the exemption from 30 TAC Section 116.610 from the concrete batch plant standard permit. In order to continue processing pending applications for registration under the concrete batch plant standard permit, the Executive Director has developed additional information that demonstrates how compliance with the requirements of the standard permit necessarily means that an applicant will also meet the emission limitations of 30 TAC Section 116.610A1. The additional information includes how the 4 primary ingredients of concrete, which include negligible amounts of crystalline silica, meet the emission limits of 30 TAC, Section 106.261. This information is at the center of the Executive Director's conclusion that the permit would be protective of human health and the environment if granted. However, given the limitations of the Executive Director's role in a contested case hearing, this information was not introduced at the hearing on the merits and is not currently in the record before the Commission. Therefore, the Executive Director respectfully recommends the Commission remand the application to SOA to reopen the record and allow for further discovery and for the ALJ to take additional evidence on the issue of the protectiveness of the concrete batch plant standard permit as it relates to the emission limitations contained in 30 TAC, Section 116.610A1. Thank you, and we are available to answer any questions.
Thank you, Ms. Browning. I have no questions at this particular moment. Commissioner Lindley, any questions for Ms. Browning?
No questions, thank you.
Commissioner Janeka?
None for me. Thank you.
Thank you. And I understand that the applicant is not going to address this. They do have some representatives signed in and available, but had not planned to make a presentation this morning. So we'll go next. The protestants. And Mr. Friedman, are you there for the protestants?
Yes, Chairman. Good morning. Can you hear me?
Loud and clear. Thank you, Mr. Friedman. Go ahead when you're ready, please.
Excellent. Thank you. Good morning, Chairman and Commissioners. On behalf of the protestants, we filed our response to the ED's motion, strongly opposed to a remand. Certainly a second hearing with the discovery necessary and the preparation and the witnesses that will need to come back is just an incredibly costly exercise, and most importantly, without any benefit or any change in where we are right now. At the first hearing, there was ample opportunity. I'm not sure the reference to the limited role by the ED that was made. Their witness testified. They participated in cross-examination. Plenty of opportunity to present evidence that the 2012 standard permit was protective and that it considered crystalline silica. And in fact, Bosky, when they were given the opportunity for rebuttal testimony, they waived that opportunity. So there was plenty of opportunity the first go round. If there were any new evidence that were to suggest crystalline silica had been evaluated back in 2012 when they did the protectiveness review, it would have been offered. And any new additional evidence that the ED says is, would show that crystalline silica is negligible, frankly, isn't the standard. The standard is 0, and there's no evidence that can be presented to demonstrate that the emission limit for crystalline silica is going to be met. And the evidence showed that the crystalline silica emissions could be significant. We don't know the answer. Bosky's witness said that the sand used at these plants, she's seen safety data sheets that show comprise 57% crystalline silica. And any additional evidence that may have been developed now after the first hearing that would show the plant is safe despite the fact it doesn't meet the TCEQ's emission limit needs to be presented during a rulemaking and an amendment to the concrete batch plant standard permit with all the participants making their comments and weighing in. So until then, concrete batch plants and this plant can pursue an NSR, individual permit. It's not a death knell to concrete batch plants in Texas. There is a path forward. And so with that, the protestants would ask the commissioners to adopt the ALJ's proposal for decision recommending denial of this permit. There's no basis for reversing her. She did not misapply any TCEQ policy. She got it right. This plant has not been demonstrated to be safe. We don't know the answer to that question, and a remand is not going to provide any further information for it. So thank you again for your time, and I'm available for any questions. Thank you.
Thank you, Mr. Friedman. I appreciate your presentation. I don't have any questions for you at this point. Commissioner Lindley, any questions for Mr. Friedman?
No, thank you, sir.
Commissioner Janeka?
Likewise, no thanks.
Let's hear from OPIC now.
Hi, good morning again, Chairman, Commissioners, General Counsel, and the Executive Directors, Attorneys, and Staff. I'm Sheldon Wayne, begin with the Office of Public Interest Counsel. And here, OPIC does not support a remand for the following reasons. The executive director testified, and the administrative law judge found that the emissions requirements in Section 106.261 and by reference 106.262 do apply to this application. And further, they prohibit emissions of crystalline silica. The record demonstrates that some amount of crystalline silica will be emitted by the facility, and the ED's motion for remand even acknowledges that crystalline silica is indeed an ingredient in concrete. In light of these facts, OPIC questions how adding to the record will demonstrate compliance with the existing standard permit, including the currently applicable emissions limitations of sections 106.261 and 262, and OPIC sees no benefit from a remand. We're also sensitive to the perception of fairness. When presented with evidence that the emissions requirements in section 106.261 do apply to its application, rather than attempting to demonstrate how it complied with the requirements, Bosky opted to insist that the section did not in fact apply. That was Bosky's choice to make it hearing, and it seems fair for the applicant to face the consequence of that choice, a PFD which is not in its favor. The group of individuals challenging this registration spent a lot of time and money. They hired attorneys and experts and developed this evidentiary record that identifies problems with the current standard permit and the issuance of this particular registration. Giving the applicant another opportunity to meet its burden through further SOA proceedings will place hardship and further expense on these protestants, after they've already expended significant resources participating in the hearing process. Those are my comments on the remand. I'm certainly happy to answer any questions, and I'm also available for any questions about OPIC's position of support for the PFD as discussed in our written filings and our presentation at the April 28th agenda. Thank you.
Thank you, Mr. Wayne. Colleagues, any questions for Mr. Wayne? Commissioner Lindley.
No questions, thank you.
Thank you. Commissioner Janeka.
Appreciate the presentation.
Thank you. I do have a question for Ms. Browning. Ms. Browning, can you articulate, help me understand what specifically you think might be shown or could be shown on remand if we were to accept the executive director's invitation to remand this item?
Yes, Chairman. We could have witnesses that could discuss how the standard permit itself, when a facility operates in compliance with the standard permit, that it would not have these emissions that are of concern. And so there was a protectiveness review that was developed with the standard permit was originally developed, and there's discussion in that original development that we do reference in our briefing about how the reason the exemption was put into the standard permit is because by operating under the conditions of the standard permit, you would not have issues with, as they say, things like crystalline silica. And it would also be possible then for us to have witnesses that could discuss whether or not and why not a concrete batch plant, even for, as Mr. Friedman discussed, an NSR permit, would most likely not have to do speciated modeling for crystalline silica because the emissions are expected basically to be so very low as to not be an issue.
All right, follow-up question. Is it possible on remand that the evidence would show that that the emissions are such that they would meet Mr. Friedman's interpretation of our standards, that there would be no emissions of silica? Is that a possible outcome of a remand?
So I can't speculate on any evidence that the applicant might choose to put forward. However, I could only say that with our understanding of how a concrete batch plant works, we could certainly have witnesses that could discuss that as a possibility and evidence could be developed on that point.
All right. Colleagues, any comments or thoughts or questions for any of the parties at this point?
None from me.
Commissioner Janeka?
Chairman, I'm going to defer to you and ask Ms. Smith for help in terms of if this is an appropriate question or not. I'm just curious to hear a little more of the point. And I apologize, I can't recall whether it was our colleagues from OPIC or the protestant who raised the point and articulated it, the argument that accepting the outcome of the findings of the PFD right now in terms of the effects on the broader industry, other applicants like this plant seeking this sort of authorization, being able to use a alternate regulatory pathway that's currently open to them. I'm just curious if any of that is fair game to hear from ED staff.
Ms. Smith?
Yes, you can ask that question.
Well, then I will ask our good executive director staff today. Have there been? Well, how has that finding? How is our agency being made aware of the oversight dating back to 2012? I'll call it in the last substantive rule change on this standard permit. How have regulated applicants in industry, how have they changed course already, or how must they? I guess my question, stated another way, is what practical application or implications for our program, our agency programs, would acceptance of the PFD and any precedent that would carry forward? What would that pose for our agency's program?
So, Commissioner, the executive director is currently involved in the project for amending the standard permit to re-add the exemption back into the standard permit. That process is already ongoing, and the proposal has been submitted to the Secretary of State for publication in the Texas Register on, I believe, May 28th. That process is ongoing. In the meantime, the executive director staff has developed some guidance and some questions to discuss with applicants to issue of how the standard permit itself, as constituted, meets those emission limitations that are at question. And I'm sorry, I can't provide the exact details.
Okay. I think I follow. I appreciate that, Ms. Browning, and I think the open discrepancy then that appears to me, which I think, Chairman, your question may have been getting to, are there potentially two different points of argument that we're making where the ALJ has focused and I think rightly identified this rule prohibition where a zero standard of silica, crystalline silica, may be a threshold that the demonstration that it meets protectiveness for health is a different demonstration, a different proving that can be compatible with some small non-zero number of crystalline silica, whereas the standard that the ALJ has found would be appropriate for this particular permit. I think I take the Chairman's question to fall right into an area that I'm still wondering myself, and that raises the question then of the appropriateness or the likelihood of an outcome, any outcome that would not be identical to this one in terms of our rules.
So I will say that the ESL is not a standard, and so we want to be careful about that. But also that we would expect to be able to put into the record the same kind of evidence that is related to the kinds of things that we're asking of applicants now to make sure if they move forward with a standard permit right now before the rule changes has gone through, that they we can discuss how the standard permit itself is such that those limits are already met if you meet the requirements of the standard permit.
I follow your point. I appreciate that. And I'm not hearing much that gives me a high degree of confidence that we're expecting to see arguments made that help support a strong argument that there is zero, that the amount of crystalline silica would meet this new test that the ALJ has identified that our rules call for these types of permits. I appreciate that. Thank you, Chairman.
Thank you.
Thank you, Commissioner Janeka. I think I need to have a sidebar with our lawyers on this.
I was going to say the same thing.
I do have some thoughts, but I want to organize them and vet them and come back with better formed thoughts than I would offer right now. So why don't we, let's see, it's 11:22. Why don't we take a short recess? Let's say 11:30. See if I can accomplish.
Chairman?
Yes, go ahead, Ms. Smith.
If we need to talk to multiple commissioners separately, we may need more than 7 minutes.
I appreciate that. Tell you what, let's how about a recess till 11:45? That'll give us a chance to stretch our legs, catch our breath, talk to lawyers, and maybe formulate some thoughts for when we return. Does that work for y'all, 11:45?
Does.
That sounds great.
All right. With that, we are in recess until 11:45. All right, colleagues, or it looks like it might just be colleague. I've got 11:45. Just rolled into 11:46, so we are back after a recess, and I guess I should begin by asking, would anyone like more time at this point? We can beg for more time later, or we can take it now. How are we doing? Commissioner Lindley?
I don't need more time, but
Okay.
I'm happy to accommodate whoever.
Commissioner Janeka?
I'm okay. Thank you.
Okay. So here's where I am with this. So let me start with where I was with this, what I was expecting this item to be about when I came into the meeting today. And I'll begin with just saying that, I expressed this the last time we met on this item. I'm confident in the scientific merits of the proposed authorization, that it will be protective of public health and the environment. This is a standard permit that we've used many times for a lot of different facilities. It's been fully vetted. The hesitation I had about moving forward was this argument that protestants made, this plain language legal argument that there is an emission limitation for silica at concrete batch plants, which equals 0. What I understood the remand to be, or what I thought it was going to be coming into this, was let's remand the item for the opportunity to take more evidence to show that the facility meets even that legal standard. Having an opportunity to hear the presentations this morning and ask questions of the parties, I'm very doubtful that they're going to show that there are 0 emissions of silica coming off of this facility. And so a remand is a waste of everybody's time and resources. So that leaves us 2 options: deny the authorization, or reverse the ALJ and grant the authorization. Now, I was hoping to avoid getting into competing legal interpretations, but given where we are and that a remand is going to be futile, that accepting more evidence is not going to accomplish anything, I think we just need to take up those competing legal interpretations and evaluate them and decide what that means for moving forward. And so let me get right to it. Mr. Friedman has proposed that, given what has been characterized as an omission, a drafting error several years back, that there is an emission limitation of 0 for silica, reading section 116.610A together with 106.261A. And hopefully, without shortcutting this too much, let me try to focus on the relevant portions of those 2 regulations. In 116.610A1, the regulations require that this project, quote, must meet the emission limitations of 106.261. So that is a reference to the other provision, and it is identifying emission limitations that the project has to comply with. So if you turn to 106.261, the relevant provision is subsection A3, and it identifies emission limitations for a whole class of chemicals including with references to 106.262. But silica isn't anywhere in that section, the first sentence of 106.261A3. It falls under the last section of 106.261A3, and that last sentence says, emissions of a chemical with a limit value of less than 200 milligrams per cubic meter are not allowed under this section. So those last few words, I think, are the key language, are not allowed under this section. So Mr. Friedman, protestants have read that language to mean that not allowed under this section means there is a limit for silica of 0. Given the, if you read all of the relevant authorities in context, consider how the relevant authorities are used in practice, considering the totality of the circumstances, considering that an emission limit of 0 is draconian and beyond what's required to protect public health and the environment, I don't think that's the best reading. I think reading those words are not allowed under this section shouldn't be read as meaning that there's an emission limit of 0. They should be read as meaning that this particular chemical, silica, is outside the scope of 106.261A3. In other words, 106.261 doesn't create an emission limitation. It's simply outside the scope of the rule. So all things considered, I think that is the better legal interpretation. And of our two choices, deny the authorization or proceed on this different legal interpretation to authorize the facility, I'm in favor of doing that. And just for your consideration, what that would look like probably is what we've done from time to time, which are, to dissect the PFD in order and create a new commission motion and ultimately order that basically overturns the ALJ. In this case, on the ALJ's interpretation of the law. So, we would, given all the work that needs to go into that and make sure that we do it carefully, we would probably continue this item yet another time in order to allow us to do that work. I don't like delaying this to another agenda, but it's better than, the waste of time that would go into a remand, and I think it gets us to a better result under the law. So anyway, that's what I'm proposing. And just to let me just put a pin in that for a moment. And I received a note that the applicant has asked to address this at this point in our deliberations. So let me afford them that opportunity, and you can hold any questions or comments you have for me about my idea. And let's take those comments now. Is there someone on the line for the applicant?
Yes, sir. This is John Sheffield from Bosque Solutions.
Good afternoon, Mr. Sheffield. Yeah. Go ahead, sir.
I just wanted to call in, and I'm under the understanding that there's new provisions on the standard permit that are going to go into effect, and all applications that are going in right now, they're required to sign a document that agreeing that they will abide by those new rules and regulations. And I just wanted you to know that whatever those regulations are, I'm willing to abide by them. My understanding is we qualify to use the standard permit, and that is what I intend to do, and I will fully comply with any regulations that you put on crystalline silica.
Thank you, Mr. Yeah, thank you, Mr. Sheffield. I appreciate that, and I think I may have interrupted you. Did you have something else to add?
No, I just was telling you thank you, and I look forward to seeing what the new rules are.
I do too. Thank you so much, sir. Appreciate it. All right, colleagues. That's my proposal. What do you think, Commissioner Lindley?
I was going to come back after the break and say some of the things you said, which is, you know, after today's discussion, I'm not convinced that a remand is where I wanted to go. I'm not sure it would get us to where we were hoping to get, or to learn more of what we were hoping to learn more about. And I don't see that as a good use of time for anyone. So then, you know, there are two options, like you were saying. Do you adopt the PFD? And what I was going to suggest was, as painful as it is for me to say another continuance, you know, I didn't want to continue to this agenda originally, but I do think there's a lot of merit in getting this right. And this one just, it is complicated. And so I'm supportive of continuing it. I would not be supportive of a remand to SOA. As far as, you know, what comes back, I was jotting down notes trying to capture the stuff you were talking about. I probably need to do a deeper dive into that to make sure I would be in agreement. So, you know, I don't know yet how I feel about, you know, whether we proceed under a new legal interpretation or just adopt the PFD. But I do think in the time it would, if we continue it, I think I can get that figured out by the time it comes back before us. So short answer, I'm supportive of continuing it and not remanding it to SOA, as painful as that is for me to say, to drag it on more. But that's what I'd like to do as well.
Thank you, Commissioner Lindley. I appreciate that. Commissioner Janeka, what do you think?
This is a very acute rock and a hard place where I think everybody who's been involved and engaged and participating very, very earnestly in this process will all be upset with any and either outcome we have. I don't think that I will disagree with the two of y'all with your suggestions and inclinations today to continue it with the chairman's suggestion that we might have a legal basis with which we could overrule the ALJ's findings in the PFD and find a way to issue the permit. And I will just simply say that I think the real difficult piece of that path forward, Chairman, that you suggested is merely the it goes right back to the statement I made at the start of my comment here that I think all the parties that have been participating really have been sincere in trying to advocate their arguments along the way in the process. It is a absurd outcome to suggest and expect for a permitting pathway to have a 180-degree turn. I'm not sure that is an outcome that serves the public need in terms of sending signals to the public that participate or the applicants come before our agency. So appreciate the chance to chime in. Very difficult question. I'm comfortable with the path forward you suggest, Chairman.
Thank you, Commissioner Janeka. Appreciate your thoughts. So let me try to summarize where I think we are on this. Sounds like we're in agreement that we're not going to remand this. That would be a waste of everyone's time. Sounds like we need more time for this. That we have apparently narrowed our options to accepting the PFD in order as is, in effect denying the permit, or the proposition that I made, which is to overrule the ALJ, and continuing this item to our next agenda would allow us to sort out our thoughts on that. You would allow protestants to sharpen their pencils for a potential drafting to exhaust their administrative remedies and perhaps ultimately to seek judicial review if we end up going that path. It's more time and burden, but we're saving the time and burden of a remand, if that means anything. So that, I think, is where we stand. Mr. Friedman has asked for an opportunity to respond to Mr. Larkin, and I think that's more than fair. So let me invite his comments now, and then maybe we can look to wrap this up. Mr. Friedman, go ahead, sir. I think I misspoke. I said Mr. Larkin. I believe I meant Mr. Sheffield. Mr. Friedman, are you there?
Yes, I am. Sorry, I was talking but on mute. So I just wanted to, in response to Mr. Sheffield's comments about willingness to comply with new regs and new requirements, that really doesn't answer the question of this case, which is not just that the emission limit is 0. I understand the legal interpretations there, but beyond that limit, the question is whether this plant is safe. And there has been no vetting of crystalline silica in 2012 or at any other time that's been demonstrated in this record. And so I just want to, it's not just anything new that's happening at the agency now that Mr. Sheffield is aware of. It is whether or not this plant has demonstrated that the neighbors are safe, and it hasn't been. And I just, I don't know if there'll be opportunity for oral argument at the next meeting, but I would like to implore the commissioners to consider that fact that this standard permit for crystalline silica has not been demonstrated to be safe, regardless of whether the legal limit is 0 or not. That's all. Thank you.
Thank you for that, Mr. Friedman. Colleagues, why don't we just, I'm not sure if we have anything more to add to this. Let me check in with you real quick. Anything to add before we, all right, seeing head nods in the negative. So let me go ahead and move that we continue old business item 1 to the June 9th agenda. Is there a second?
I'll second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. Motion carries. Ms. Smith, I believe we're on item 3 now.
That is correct. Item number 3 is the application by Steel Dynamics Southwest LLC for new TPDES permit number WQ000-528-3000.
Thank you, Ms. Smith. And for the benefit of those who are not familiar with our process, we have a 2-part analysis for considering requests for contested cases, beginning with whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Associations can be deemed affected persons if, among other requirements, they identify a member who is an affected person in his or her own right. So, colleagues, we have numerous requesters in this matter. Many of them failed to meet the requirement to provide an address at all. Those who did provide an address, of those who did provide an address, the closest is more than 15 miles from the facility, and the rest are more than 20 miles from the proposed facility. And although there are other procedural and substantive issues with some of the requests, given the distances, none of the requesters can be affected in a manner different than the general public. So I agree with the Executive Director and the Office of Public Interest Counsel that we should deny all of the hearing requests. Commissioner Lindley, I imagine you may have arrived at a similar conclusion.
I did.
Thank you. Commissioner Janeka, the same?
Likewise.
I think we're ready to entertain a motion.
I have a motion. I can start. I would move that we deny all hearing requests, that we issue new TPDES permit number WQ000-528-3000 to Steel Dynamics Southwest LLC as recommended by the Executive Director, and adopt the Executive Director's response to comments.
I second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 4 is the application by Marbeck LLC for new TPDES permit number WQ00158800001. The parties have been.
Oh, go ahead.
I was just going to say that the parties have been notified that there will be no oral argument, and we have no one signed in on this one.
Thank you, Ms. Smith. Colleagues, again, we have a two-part analysis for considering requests for contested cases. Part 1 is about who gets a hearing, as I just articulated, and Part 2 is about which issues are referred. In this case, we have a single requester, and that is Pilot Land Acquisitions, which has property in close proximity to the proposed facility and discharge route. And really, despite the proximity, this was a little bit of a close call for me. So if you don't mind, I'd like the benefit of your thoughts before I really commit myself one way or another. And I'm going to go from left to right again, Commissioner Janeka, and pick on you to go first if you want to share your thoughts on this.
I think I am in agreement with OPIC rather than the executive director on this particular item in terms of the effectiveness for the parties. I found very compelling the arguments about the discharge into a swale in the land, and I think that is a fair point that would confer effectiveness and could get me forward to get me to the point of recommending that one single open issue to SOA.
Thank you, Commissioner Janeka. Commissioner Lindley, what do you think?
I'm glad to hear you are a little torn. I am a little torn on this one too. And it really came down for me going back and reading not Mr., excuse me, it was a gentleman, but Pilot Land's Acquisitions comment. My initial read was it is a little bit of a stretch to say what came in the first comment. Kind of covered what came in the request for reconsideration, because I think the request for consideration is really where it's a little more substantive comment. I probably shouldn't go down this hole too much, but anyway, there was a lot of discussion on property rights, which we don't have jurisdiction over. But I do see how OPIC got there as far as finding that those comments made during the regular comment period qualified as substantive and within the requirements of Senate Bill 709. So all that to say, I think I'm comfortable now granting a hearing request. I would only refer one issue, if we wanted to do that, I would even say let's try and go for 150 days, try and shorten it since it's one entity and one issue, and deny the request for reconsideration. So I didn't say a whole lot there, but hopefully you got what I was trying to say. But I welcome your thoughts. This one was a little tricky because because you are right next door doesn't necessarily. There's more to it than just proximity. I guess I'll leave it at that.
Right. Yeah. Thank you, Commissioner Lindley. And I think 150 days would be appropriate. I think it is appropriate to refer this. And my hesitation was actually I thought that the requester had fairly identified a relevant and material issue. I was struggling with did the requester articulate a personal concern? What exactly is that concern that is within our jurisdiction? And I heard property rights, and that's not it. So it's a close call for me. But given that this is a pro se requester, and that the property surrounds the proposed facility in very close proximity, I think the requester got close enough. So I would support a motion along the lines that you that both of you identified a single issue motion granting the request and Commissioner Lindley setting a hearing duration of 150 days. So I think I'll entertain any more thoughts or discussion, but I think we may be ready for a motion.
I think I can get that motion made with the suggested revision to the hearing duration that Commissioner Lindley made. I move that we grant the hearing request of Pilot Land Acquisitions, LLC, refer the application to SOA for a contested case hearing on the following issue: whether the application properly characterizes and the draft permit properly addresses the discharge route. Refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process. Set a hearing duration of 150 days from the date of the preliminary hearing until the proposal for decision is issued, and deny the request for reconsideration.
A second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 5 is approval to publish and solicit comment on the draft 2022 Texas Non-Point Source Management Program. The Executive Director staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Terry Neiman with the Water Quality Planning Division in the Office of Water. With me today are Faith Hamilton with the Non-Point Source Program and Stephanie Scogan with the Environmental Law Division. Today, the Executive Director is respectfully requesting approval to release the draft 2022 Texas Non-Point Source Management Program for public comment. The draft document was jointly developed by staff of the TCQ and Texas State Soil Water Conservation Board, is a requirement of the Federal Clean Water Act, and must be updated every 5 years. It outlines the strategy in Texas to protect and restore water quality impacted by non-point source pollution. The document incorporates EPA's 8 components of an effective program, establishes long and short-term goals for the program, and provides for the coordination of the program and activities with other partners. Preliminary input was sought and obtained by stakeholders and the EPA at a virtual stakeholder meeting held on October 7, 2020. The Executive Director respectfully requests approval to publish the draft 2022 Texas Non-Point Source Management Program for public comment. Permission is also requested to make non-substantive and clerical corrections before providing the document for public notice. Thank you, and we are available to answer any questions that you may have at this time.
Thank you, Mr. Neiman. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No questions. I appreciate staff's work in keeping us on this 5-year update schedule with EPA.
Thank you, Commissioner Janeka. Ms. Smith, has anyone signed in to speak on this item?
No one is signed in.
And let's gather the Office of Public Interest Counsel's ideas.
Vic McWhorter here, Public Interest Counsel. OPIC supports publication of the draft 2022 Texas Non-Point Source Management Program as recommended by the Executive Director.
Thank you, Mr. McWhorter. And colleagues, I echo Commissioner Janeka's sentiments of gratitude for all the great work that's gone into this. I think it's appropriate to put it out for comment. And I think I'm ready to entertain a motion or any additional thoughts. Commissioner Lindley?
I've got a motion. I would move that we approve the publication of and solicitation of public comment on the proposed 2022 Texas Non-Point Source Management Program as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
I also vote aye.
And I vote aye as well. The motion carries. Ms. Smith, please call the next items.
That takes us to our enforcement docket, items 6 through 32. The Executive Director staff is here to present these matters.
Good afternoon.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division representing the Executive Director. Pending before you are items 6 through 32. The total assessed administrative penalties are $613,474, with $53,491 deferred, $188,406 applied towards supplemental environmental projects, and $371,577 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none at this point. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Likewise, thank you.
Thank you. Ms. Smith, I think I noticed one registration card of Mr. Blanco wishing to address the commission on item 27. Were there any other interested persons wishing to speak on this item?
So I'll note that on items 15 and 31, we have individuals signed in who indicated that they don't wish to speak, that they're there if the commission has any questions, and that their presence will be noted for the record. And then we have interested persons registered on items 7 and 27 who do wish to address the commission. And to allow time for all who wish to be heard during the meeting, OGC would recommend limiting each speaker to 3 minutes. On item 7, we have Tracy Sullivan. And on item 27, as you noted, Carlos Blanco. And then Ms. Kristen Adams from Rio Grande Legal Aid is available to answer questions. And Mr. David Arredondo from the City of Laredo is also available to answer questions.
Thank you, Ms. Smith. I do think 3 minutes is appropriate, and let's begin with Ms. Sullivan on item 7. Good afternoon.
Good afternoon. How y'all doing?
Doing well. Thank you, Mr. Sullivan. Sounds like I apologize.
Yes, sir. No problem.
Go ahead when you're ready, sir.
Okay, this is the first time doing this. Just bear with me here. We've all started in 2014. At the time, we were in business and doing good. And, we had arrangements to have the facility up and ready by a certain time, and then the oil field had crashed. And we basically hadn't been in business since then. And I believe in 2019, a gentleman come by and had people there clean up the facility, but we were not doing any sandblasting or painting. Matter of fact, we were just trying to do whatever we could to get by. I'm not sure if any of this is relevant to the case now. And I talked to Mr. Christopher Mullins and explained to him about the finances, and I was kind of under the impression that it was up until this point that it decided on, when to file that. But I'm wrong at that point. I spoke with him earlier, so I'm not sure what I need to do.
Okay. Well, thank you, Mr. Sullivan, for dialing in here. Having not responded to the process in this is really what landed us in the posture of a default order on this, and which is a difficult place to be. Let me just put a pin in this item for now, and I'll come back and share some thoughts on it later on this set of agenda items. But for now, let me move on to my colleagues. Commissioner Lindley, any thoughts or questions for Mr. Sullivan?
No, thank you.
Commissioner Janeka?
I think what I hear, Mr. Sullivan, is there was a bit of a misunderstanding from your company's end in terms of at what point and when to respond and participate in our process in order to
yes, sir.
Assert limited ability to pay. I appreciate very much that concern and that frustration, and I'll just voice my sympathies to that end. But I appreciate. I'll wait and follow up as well with the chairman on this one. I'm sensitive to neither wanting to disadvantage the members of the public who come through our agency's processes and may not be familiar with it, but also not to put on an uneven playing field those individuals against all the rest of the entities who do come and go through our agency's patterns in and out. So I appreciate you're making a comment today. Thank you very much.
Yes. Thank you.
Thank you, Commissioner Janeca, and thank you, Mr. Sullivan. Let's hear next from Mr. Blanco on item 27. Mr. Blanco, are you there?
Am I unmuted now?
You're unmuted. You're coming through loud and clear. Go ahead when you're ready, please.
Sir, Chair, before we proceed, I want to share with you that down here in Laredo, I don't know whether you guys know, but we've been getting very bad rainstorms, so my internet has been shutting on and off intermittently all morning long.
Okay. Well,
I hope I don't lose you. Now, go ahead, Mr. Chair.
Yeah. Thank you. Thank you for joining us, Mr. Blanco. Let's just try it. See if you can get your 3 minutes in, and if you get disconnected, we'll try you back. We'll just keep trying.
Thank you. And I will go ahead and start here. My name is Carlos Blanco Jr. I'm a representative for Acción de Gente Unida para Aguas Seguras, which is the acronym is AGUAS. In English, it's Action of United People for Safe Waters, which filed a comment in opposition to a proposed agreed order between the City of Laredo and TCEQ that is on your agenda today. AGUAS and the families it advocates for strongly oppose the proposed agreed order. The agreed order involves boil water notice violations by city officials that demonstrate that TCEQ is primarily concerned with allowing violators to save face than in deterring violators from violating the Safe Drinking Water Act standards again and again. For over a week in September 2019, thousands of people in Laredo barrios consumed drinking water that was potentially unsafe to drink. They consumed the water when they should have boiled it first. They didn't boil it because the City of Laredo officials disobeyed TCEQ's strict rule that the boil water notice must be issued within 24 hours after the water quality falls below EPA TCEQ standards under the Safe Drinking Water Act. City officials refused to issue the boil water notice for 7 days to save face, not to save people's health. TCEQ owned investigation reveals there was no valid excuse for City of Laredo officials ignoring the boil water notice rule. City of Laredo officials have in the past shown growing indifference in providing standard safe drinking water to low-income areas of Laredo, as was the case here. The complaint alleged to TCEQ to mandated boil water notice and now the agreed order before the Commission today was brought by a citizen who lives in Barrio Azteca, a low-income area in South Laredo. City officials passed the buck over several days on his complaint of bad water flowing out of the household faucet. Had it been an issue in the wealthier side of Laredo, this would not have occurred. Though TCEQ knows all of this, it is now set to rubber stamp its approval of an agreed order that allows city to deny.
Mr. Blanco, I fear we may have lost you in your last minute. Are you able to hear me? And more importantly, are you able to respond?
Perfectly. Can I respond?
Yep, I hear you now. Go ahead.
Did the City of Laredo respond in such a tardy manner to issue out a boil water notice in September 2019 because it only affected the oldest parts of town or the most stricken with poverty? I would suspect discrimination was the case. This holds true for the city's failure to maintain a good condition of water tank storage located in South Laredo. The city has known for quite some time the tank has leaks, but ignored the responsibility to fix the tank. The agreed order is not acceptable to AGUAS because it lets city officials believe that even if city officials are culpable for violations of the Safe Drinking Water Act, TCEQ will allow them to save face by allowing them to deny any wrongdoing, and that TCEQ will assess the slap in the wrist penalty so small in relative terms a drop in the bucket for violating the Safe Drinking Water Act that they can laugh it off. This will boil down to the agreed order that is ineffective to deter future violations, but a slap in the face to consumers who were the victims of the Safe Drinking Water Act violation. I'm almost through. For all these reasons and those cited in AGUAS, comments submitted to the Commission, AGUAS respectfully request that the Commission not approve the agreed order, but instead require findings that provide admissions by the City of Laredo wrongdoing. Thank you, President Chair, and to the committee in general.
Mr. Blanco, thank you very much for being with us this morning and sharing your comments on this.
If I may, Mr. Chair.
Go ahead, sir.
Chairman, I want to thank the organizer, Megan Tack. She went beyond the call of duty, setting me up for this opportunity to address the board.
Thank you, Mr. Blanco. We are lucky to have her. She's fantastic. So, we always like to hear compliments about our staff. They probably don't hear them as much as they deserve them. But thank you for that, sir, and thank you again for your comments.
You're welcome.
Ms. Smith, is there anyone signed in wishing to speak on the enforcement docket?
No, as I noted, Ms. Kristen Adams with Texas Rio Grande Legal Aid and Mr. David Arredondo with the City of Laredo are available on this item if you have questions.
Thank you. And in fact, I do have some questions for Mr. Arredondo. Sir, can you unmute your microphone? And I want to pose a couple of questions to you. Number one is can you provide an explanation of what happened specifically with respect to the late boiled water notice? Our agency advised the City of Laredo that it had a legal obligation to issue this notice, and yet the notice didn't go out for more than a week. And so my first question is, what happened?
Good afternoon. This is David Arredondo Jr. with the City of Laredo Attorney's Office. This enforcement action actually predates my involvement with the City of Laredo, but my understanding was there was some concern about test samples that may have been contaminated, and so I believe we were waiting on test results before the boil water notice was issued.
Okay, so when the regulator looked at, and that is our agency, the TCEQ, looked at the test samples and instructed the city that it had an obligation to issue a boil water notice, the regulated entity was arriving at a different interpretation, that that's not actually what was required. And are you familiar with the conversations that may have ensued between the agency and the city at that point?
Beyond what was included in the response to the public comments, no.
Okay. Well, respectfully, Mr. Arredondo, I feel like the city may have sent the wrong person today. I think we would like to hear from somebody who's more familiar with the history. And candidly, this is a very significant violation. And it is troubling that any supplier of public drinking water would wait for more than a week to warn its residents about potentially hazardous drinking water. I think of everything we regulate, nothing provides a more immediate and acute risk to public health than drinking water that is suspect. So my next question was going to be, what has the city done to prevent this from happening again? But it sounds like the city thought that it was, within its rights and good judgment by questioning the determination of this agency, which to my mind is the wrong answer. So I'm not going to ask you that question. I think I have the answer to it already, at least with respect to your familiarity with the matter. So what I'm going to propose we do is invite somebody from the City of Laredo to our next agenda who is more familiar with the history, so we can impress upon them the importance of the notification requirement, and so we can hear directly from a knowledgeable person what the city intends to do in the future to prevent this from happening again. Now, Mr. Blanco complained about the form and fashion of the order, and let me say this about the agreed order. I don't have a particular problem with the penalty. I understand why people perceive that it's a low penalty. Our penalty was calculated under our statutory authority consistent with our penalty policy. It appears low to me. These drinking water orders all appear to have low penalties. I think there is a policy reason behind that, and that is leave some money in the pockets of the ratepayers of these facilities so that they can improve their drinking water systems rather than taking those monies in penalties. But I can appreciate why people think it may be a low penalty. I don't have a problem with the penalty or that this is not a findings order. I think under our policies and procedures, that's appropriate in this case. The important thing to me is that the city acknowledges what it's done here, and we get some confidence that it's not going to happen again. So I appreciate you being with us today, Mr. Arredondo and Mr. Blanco. I appreciate your comments, and colleagues, I'm going to suggest that we continue this item 27 to the next agenda. As for item 7, I don't see anything in the backup that could really help justify doing anything different with respect to Mr. Sullivan's predicament on the default order. I haven't heard anything today that would convince me that we've erred in any fashion. So with those thoughts out there, let me get any thoughts or reaction from you, Commissioner Lindley.
I'm in agreement. I'm fine continuing item 27. I do think at the end of the day, I will be most comfortable adopting, what's in the backup, what was presented today as far as actual penalty amount and agreed order. But I'm perfectly fine continuing it to June 9th so we can discuss more.
Thank you. Commissioner Janeka?
I appreciate the questions, Chairman, and I guess the only open item for me was to ask, would it be possible to ask ED staff if they might have any response or additional context in response to the comments made on item 7. I appreciate the point that the default order where the applicant is now here before us, but I certainly would love to hear from ED if they have anything of relevance on that particular item.
I think that's a fine idea. Thank you, Commissioner Janeka, for that. Ms. Cordell, do you or any of your team members have some thoughts to offer on item 7?
Good morning, Chairman. This is Charmaine Backens with the Litigation Division, and I can answer Commissioner Janeka's question or address his concerns. Christopher Mullins is a staff attorney assigned to this matter, and he was in contact with Mr. Sullivan since the beginning of the year when this was first referred to the Litigation Division, and spoke with Mr. Sullivan on several occasions, explaining the process to him and actually informing him that the financial inability to pay process review was available to him if Mr. Sullivan would just file an answer. And so on a couple of occasions, Mr. Mullins advised Mr. Sullivan to file an answer, and so we could begin that process, and Mr. Sullivan unfortunately failed to do so.
I appreciate that. Ms. Backens, thank you so much. And I think that was about what I expected, but I appreciate having a little more detail from ED on the efforts that we took in our process.
Thank you, Commissioner Janeka. Thank you, Ms. Backens. Let's hear next from OPIC. Mr. McWhirter.
Good morning. First, with respect to item 27, I support your proposal to continue this item. I had some other comments about it, but they can wait, and hopefully when the appropriate representative from the city's utilities department comes next time, I might have some other comments with respect to that item. And also, with respect to all the other items on your enforcement docket, my office reviewed all the enforcement orders, and we recommend approval as proposed by the executive director.
Thank you, Mr. McWhirter. I appreciate that. Colleagues, I think I'll just go ahead and move that we adopt items 6 through 26 and items 28 through 32 as recommended by the executive director, and continue item 27 until the June 9 agenda. And I'll invite any additional thoughts or a second. Commissioner Lindley.
I have no thoughts.
Commissioner Janeka.
I will start by seconding, but chime in with some thoughts. Chairman, thank you so much for the suggestion on how to handle the item. I think that I can't improve on your words or your description of your thoughts on that matter at this moment. So I agree with everything you said. And I'll merely convey to Mr. Arellano, thank you for coming before us today. Thank you for providing what information you could. I think I agree with the chairman. It's clear to me that you were not the most familiar person with this matter to be able to speak to the concerns that we have. And I would encourage you and your supervisor and perhaps their supervisor to find someone appropriate at that level of the organization, the city, to come visit with us and give us some answers to the particularly what I consider to be troubling public comments and discussion about the responsiveness to our agency's obligations and requirements. And I'll echo the chairman's concerns about the importance and urgency of conveying to the public any potential concerns for water. And if there's uncertainty in tests, I hope that all of our public water systems in the state consider strongly the value in honest communication with the public to let them know, we're giving you a boil water notice today. Here's the additional information that we may not be required to tell you, but that will help you understand why we're giving you a boil water notice. And then come back the next day to remove that if there was confirmatory survey work or sampling that needed to be done. I think that certainly could cause public concern, but only by starting to take these obligations seriously can we, as public institutions in Texas, really build that level of confidence from our public. And where it appears to me that your local public have some real concerns about your city as an earnest stakeholder in serving all of its residents equally, I think those are the same sort of concerns that our agency sees and faces in the way that we comport ourselves. And we take that very seriously. So it's disappointing to me to see it when our counterparts in public government maybe aren't fulfilling their obligations to the highest standards as well. So I appreciate you coming before us today, but I would urge you to convey with as much enthusiasm as you can to your colleagues at the city the need to bring the appropriate representation at our agenda next opportunity. Thank you.
Thank you, Commissioner Janeka. And I'm not sure if I heard a second. Somebody want to second the motion?
I did at the start. I'll second it again.
Okay. All right. Well, we've got 2 seconds on another motion. So the motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
And Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item 33 is consideration of the monthly enforcement report. The Executive Director's staff is here to present it.
Good afternoon.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Brian Sinclair of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Charmaine Backens of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2021 through March. There were 554 effective administrative orders issued, and of those, 78 contained supplemental environmental projects. These orders assessed a total of $6,130,802 in penalties, with a payable amount of $3,774,124. $1,299,715 are to be paid towards supplemental environmental projects. 8,443 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 987 enforcement action referrals have been received. There are 1,606 pending administrative orders, with 262 cases that are on backlog. 208 cases are pending at the Attorney General's office for representation in district court, and 7 judgments have been issued. 2,099 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2019, 2020, and 2021. We are available to answer any questions you may have.
Thank you, Mr. Sinclair. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No, thank you.
Ms. Smith, has anyone signed in to speak on this item?
No one is signed in.
Thank you. And Mr. McWhorter, what are your thoughts?
Thank you for the report. I don't have any questions.
Thank you, Mr. McWhorter. And Mr. Sinclair, thank you again for the report. I appreciate it. No action is necessary on this item. So, Ms. Smith, I'll ask you to please call the next item.
Item number 34 is the consideration of a petition for rulemaking filed by B&J Wakefield Services Incorporated to amend 30 Texas Administrative Code, Chapter 285, concerning on-site sewage disposal systems. B&J Wakefield Services, represented by Mr. Brian Wakefield, is the petitioner and may present this matter, followed by other interested persons, if any, the ED and OPIC. OGC recommends limiting speakers to 5 minutes each for their presentation. And I understand from the Chief Clerk's office that the petitioner was on the line earlier but may have dropped off, and we don't have anyone signed in on this item.
Thank you, Ms. Smith. Well, let's try for Mr. Wakefield. Are you with us, Mr. Wakefield? Well, it's been a long morning. I don't blame him for not sticking around, but we'll try to come back to him at the end here. And Ms. Smith, you said no one has signed in, so let's hear from the Executive Director. You might check your line to make sure it's unmuted. Is there someone from the Executive Director's
Hello,
office?
can you hear me now?
Yes, yes.
I'm so sorry, my microphone just went out. Good morning. My name is good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Shannon Frazier, Work Leader of the On-Site Sewage Facility Program with the Program Support and Environmental Assistance Division. With me today is Ms. Christy Mills-Jurok, Deputy Director of the Program Support and Environmental Assistance Division, and Ms. Kathy Humphreys with the Environmental Law Division. On April 5th, 2021, the TCEQ received a petition for rulemaking from B&J Wakefield Services Incorporated, requesting revisions to 30 Texas Administrative Code, Chapter 285, On-Site Sewage Facility Rules Compilation. The petition proposes to amend the reporting requirements in Subchapter 285 by requesting that OSSF maintenance providers only be required to submit maintenance reports to the permitting authority or authorized agents for OSSFs that are failing or systems that are in need of repair. The petition also requests a revision to allow the use of approved direct bury wiring and sun-resistant sheathing, and to allow that electrical connections be watertight in lieu of being in a junction box. The Executive Director has concluded that additional stakeholder input is needed to determine which of the petitioner's requested rule revisions are appropriate. The Executive Director respectfully requests authorization to perform the review of this petition concurrently with the petition previously filed by the Texas On-Site Wastewater Association, Inc., docket number 2020-1450-PET, project number 2021-003-PET-NR, the agenda date of December 20th, 2020, which has been approved by the Commission for Stakeholder Engagement and Rulemaking. Thank you, and we are available for any questions you may have.
Thank you, Mr. Frazier. I appreciate the presentation. I have no questions. Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
None. Appreciate it.
Thank you. And Ms. Smith, has anyone signed in to? Oh, we already asked you that, and you said no. I think we're down to OPIC. Mr. McWhirter, what are your thoughts?
OPIC agrees with the Executive Director's recommendation to grant the petition and invite stakeholder input about the need for the proposed rule changes. We also support the ED's request to review the petition concurrently with the previously granted petition of the Texas On-Site Wastewater Association.
Thank you, Mr. McWhirter. I do too. I agree with that. I want to begin by thanking Mr. Wakefield for raising these issues. You know, our rulemaking process will allow all the stakeholders to weigh in, but on first blush, these certainly appear to be good ideas to me. I also want to be clear about how these petitions work, so we're not raising expectations too much. And if we like a petition, we will initiate a rulemaking process to examine the issues and perhaps, but not necessarily, that's the important part, not necessarily adopt new or revised rules as a result. So we're not going to predetermine the outcome, but I do think that these look like good ideas heading into the stakeholder process. And in any event, I do think we should initiate rulemaking on this petition. And let me get your thoughts, colleagues. Commissioner Lindley.
I'm in agreement, and I appreciate the way you laid that out. I have a motion if we're ready, but don't want to cut off. I'll go ahead.
Go ahead.
I would move that we direct the executive director to initiate rulemaking to examine the issues raised in the petition for rulemaking filed by B&J Wakefield Services Incorporated concerning amendments to 30 Texas Administrative Code, Chapter 285.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Smith, please call the next item.
Item 35 is the consideration of the publication of and hearing on amendments to 30 Texas Administrative Code, Chapter 335, related to the increase in industrial and hazardous generator and management fees. The Executive Director's staff is here to present the item.
Good afternoon.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Garrett Heathman with the Waste Permits Division. With me is Jarita Sepulveda with the Waste Permits Division and Audrey Leiter with the Environmental Law Division. The proposed rulemaking would amend 30 Texas Administrative Code, Chapter 335, Industrial Solid Waste and Municipal Hazardous Waste, Section 335.323 and Section 335.325, relating to waste generation and waste management fees. A virtual public hearing will be offered on this proposal on June 29th at 10 a.m. 2021. Staff respectfully recommend approval to propose the publication of and hearing on 30 Texas Administrative Code, Chapter 335, Industrial Solid Waste and Municipal Hazardous Waste. Staff also respectfully request permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Mr. Heathman. I have no questions. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No questions. Thank you all for taking a much-needed look at this fee component of our program.
Thank
Ms.
you.
Smith, anyone signed in to speak on this item?
No one is registered on this one.
Thank you. And Mr. McWhorter, what are your thoughts?
OPIC recommends approval for publication of and hearing on the proposed amendments of the Commission's Chapter 335 rules as presented by the Executive Director.
Thank you, Mr. McWhorter. Colleagues, I think you probably feel the same way. I don't enjoy raising fees, but we do need to keep our program solvent, and we haven't raised fees in more than a quarter of a century, so I do think it's appropriate to move forward and hear from our stakeholders on these ideas. Commissioner Lindley, what do you think?
You said it very well. I'm in agreement.
Commissioner Janeka?
Likewise, and I will simply move that we approve the publication of and hearing on amendments to 30 Texas Administrative Code, Chapter 335, as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 36 is the consideration of agency post-incident response actions related to the February 2021 severe winter storm, including plans to evaluate factors that impacted public water system response and recovery actions. The Executive Director's staff is here to present this matter.
Good afternoon.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Brittany Wortham-Teakle, Special Assistant for the Plan and Technical Review Section in the Water Supply Division. With me today is Carrie Michelle LaKyle, Deputy Director of the Water Supply Division. I'm here to provide the Winter Storm Uri After Action Review Project Team's monthly status update for the work completed to date and next steps for the project. The project team completed the development of the survey that includes questions related to impacts of the storm, as well as questions about the actions taken by systems that mitigated impacts of the storm. A postcard with the link to the survey was mailed on May 3rd to each public water system, as well as other agencies and associations to solicit survey participation. We are now starting to receive survey responses. Our next main area of focus, as the survey responses are received, is to plan the roundtable discussions. We are currently working with IRD to develop a registration process for these roundtable discussions. We anticipate hosting the first of these discussions in July, and we'll be posting the registration links on our project webpage approximately 30 days prior to the first event. We will advertise once registration is open. Moving forward, the project team will begin to compile the data as survey results are received, conduct a literature review for best practices, talk with industry experts, and plan for weather-related readiness and resiliency topics, including case studies and lessons learned, presentations, and trainings to be provided at the annual Public Drinking Water Conference in August. That concludes my update of the Winter Storm After Action Review project. We welcome any feedback that you may have, and I am available to answer any questions.
Thank you, Ms. Tickle. I have no questions, but a comment, and that is simply that I applaud you and your team's efforts and keep up the great work on this. It's a really important issue, and so we need to get it right, and I know you're doing that, so thank you for that. Commissioner Lindley, any questions or comments?
I ditto your comments, and I don't have any questions. Thank you.
Thank you. Commissioner Janeka.
I could not emphasize enough how much this issue remains very live and urgent in our state. I recall an article over the last couple of weeks where I saw a public water system considering or may have approved a couple $100,000 of infrastructure costs just to keep a Plan B option open for one of their input needs. So I think that this is a question we're all grappling with across the state, and I'm grateful for your work. Thank you.
Thank you, Commissioner Janeka. Ms. Smith, has anyone signed in to speak on this item?
No one is registered on this one.
Thank you. And Mr. McWhorter, what are your thoughts?
I don't have any questions. I appreciate all the thought and effort staff's putting into this, so thank you.
Thank you, Mr. McWhorter. Colleagues, there's no action necessary on this item, so Ms. Smith, I'll ask you to call the next item.
Item number 37 is the consideration of TCEQ's fiscal year 21 semi-annual historically underutilized business subcontracting expenditures. The Executive Director's staff is here to present.
Well, good afternoon.
Good afternoon, Mr. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Clarabelle Diaz, Hub Coordinator of the Financial Administration Division. I have with me Chris Goldberg, PNC Section Manager of the Financial Administration Division. We are representing the Executive Director. The TCEQ Hub Coordinator reports, communicates, and provides information directly to the agency's executive director, and commissioners on a quarterly basis. To assist TCEQ with Hub compliance, the duties and responsibilities of our Hub coordinators include, but are not limited to, facilitating compliance with the state agency's good faith effort criteria, Hub reporting, contract administration, and marketing and outreach efforts for Hub participation. TCEQ currently ranks third in Hub utilization among all state agencies spending more than $10 million per year. The Texas Comptroller of Public Accounts prepares a consolidated report on a semi-annual and annual basis, which is based on compilation and analysis of the reports submitted by each state agency, including TCEQ and other information available to the Comptroller. This item contains a summary of TCEQ fiscal year 21 semi-annual historically underutilized business, Hub, subcontracting expenditures for goods and services between September 1, 2020 through February 28, 2021. Reported data includes the Texas Comptroller of Public Accounts statewide Hub program is based on good faith effort and does not have a statewide Hub overall utilization. The state overall Hub utilization for the fiscal year 21 semi-annual report is 8.4%. TCEQ overall utilization for the FY21 semi-annual report is 36.75%. The special trades procurement goal is 32.9%. TCEQ Hub utilization was 31.96 for the first half of the year. Special trades at TCEQ consist of air monitoring installation and building and maintenance repairs. The professional services procurement goal is 23.7%. TCEQ Hub utilization was 12.16% for the first half of the year. Professional services at TCEQ consist mostly of environmental engineering services, and utilization is derived predominantly from indirect payments to hub vendors. The other services procurement goal is 26%. TCEQ hub utilization was 39.01% for the first half of the year. Other services at TCEQ consist of direct contracts to prime hub contractors for information technology and services. The commodity procurement goal is 21.1%. TCEQ hub utilization was 41.13 for the first half of the year. Commodity purchases consist of active hub vendors for computer equipment and...
Oh, Ms. Diaz, I think we may have lost you. Are you there? Ms. Diaz? Darn.
Council Business Expo and the Southwest Minority Supplier Development Council Premier Expo. TCEQ hub participation by ethnicity groups, service disabled veterans, and women-owned business will provide the actual hub goal percentage on this category during fiscal year 21 semi-annual reporting period. The following are TCEQ current contracts ethnicity participation. Women-owned, 24.51%. Asian Pacific, 4.88%. Hispanics, 4.31%. African Americans, 2.45%. Disabled service veterans, 0.36%. Native American Indians, 0%. I am available to answer any questions you may have. Thank you.
Thank you so much, Ms. Diaz. I appreciate that. And just for a little context, TCEQ and really all or most state agencies have been working for many, many years, decades really, on goals towards contracting with historically underutilized businesses. And these are reports that we've had periodically going back years and years. And the notion with including one in this formal agenda was to provide a little bit more transparency with the public to let them know about our efforts on a semi-annual basis. So that's why this agenda item is here today. And Ms. Diaz, I certainly appreciate your presentation today. Again, I don't have any questions, but let me check with my colleagues. Commissioner Lindley, any questions or comments?
No questions. Appreciate all the hard work that goes into compiling that report. Thank you.
Thank you. Commissioner Janeka.
I sincerely appreciate the way that the data were broken out. I think it helped give a much better understanding for where our agency, though we're far surpassing the general statewide hub utilization goal, where we have opportunities to try to continue to work and do better in our subcategories. So thank you so much, Ms. Diaz.
You're welcome.
Thank you, Commissioner Janeka, and thank you again, Ms. Diaz. Ms. Smith, has anyone signed in to speak on this item?
No one has signed in.
Thank you. And Mr. McWhirter, do you have any thoughts on this item?
No particular thoughts. I appreciate the report. It is interesting and helpful to hear the information broken down the way that it was. So I appreciate that, and thank you very much.
Thank you, Mr. McWhirter. And colleagues, there's no action necessary on this item either. So Ms. Smith, I'll ask you to call the next item.
Item 38 is our public comment session, and we currently don't have anyone signed in to speak at this time, but we'll pause and allow the line to be open for a moment in case anyone is there. Hearing no one, that takes us to the end of the items posted for open session. The Commission will meet in closed session today via video conference or teleconference at, would you like to give everybody about at least a 15-minute break? Longer? What time?
Colleagues, can I propose a 30-minute break? I'm trying to juggle some other meetings and obligations, and if that works for your schedule, That would sure would be helpful for me. So adjourn. I shouldn't say adjourn. Recess this meeting, and then rejoin executive session at 1:30.
Sounds good.
Does that work? All right. Okay. Thanks to both of you. I appreciate that. That really helps me out.
So the commission will meet in closed session at 1:30 as permitted by the Open Meetings Act, including Texas Government Code sections 551.071 and 551.074, and the Governor's March 2020 executive order regarding the Open Meetings Act to take up and consider matters pursuant to items numbers 39 through 42 as posted and noticed.
Thank you, Ms. Smith. So colleagues, I'll see you at 1:30, and then someone will return to this forum to gavel out, likely our general counsel. So with that, the time is 1:01, and we are in recess.
Hey, Mary, can you hear me?
Yes. Can you hear me?
Yes, ma'am.
Are you guys ready?
Yes, ma'am.
Okay, the commission met via video conference for closed session from 1:31 p.m. until 2:22 p.m. on item numbers 39 through 42 as posted in notice pursuant to Texas Government Code section 551.074. No action was taken. The agenda stands adjourned and the time is 2:25.